Hello. So for today's stream, we will hopefully be closing up this chapter on DOBBS v. Women's Health Organization. This will be kind of the end of a long series. We started out by listening to the oral arguments, then we moved on to reading the majority opinion, and in the last stream, we looked at some of the concurring opinions. I think we have one more concurring opinion today, one or two, and then we'll kind of move on to the dissenting opinions, and then we'll be all done with the case. So if you've missed any of those previous streams, feel free to check out the YouTube and just look up Supreme Court or some combination of keywords like that, and you should be able to find all of them. I'll probably end up putting those together in a playlist for your convenience, and that's the plan for today. We'll, of course, have Pisco 95 on, so he'll offer some commentary on what the justices are talking about. He and I both are excited to finally get into the dissenting opinions, which are going to be the people that disagreed with the majority opinion, and a little bit of reasoning for why they disagreed with the majority opinion. Because up until this point, we've mostly covered people that all agree with the ruling, all are, anti-Roe v. Wade, and so we'll finally get a little bit of a taste breaker today listening to the dissenting opinions. So if any of that interests you, feel free to continue with today's stream, and I'll hopefully be going back and time-stamping the last stream as well today. There's a lot of little things I need to do after stream today. We also did a YouTube video on the Obergefell case, and with a lot of the terms that we've been talking about with the Supreme Court stuff. That's all edited and ready to go, and I'll probably drop that as soon as today's stream is over, if I remember to do that. And yeah, that's the plan, Stan. Kagan is about to pop off. Yeah, we'll see. What's up, everybody? Top of the morning to you. I am in England, so I don't know if I can use that accent, but I'm glad we are reading from the legitimate justices on the 4th. Oh yeah, it is the 4th of July. I totally forgot about that. Maybe I should remove the British flag from our little whiteboard today. But yeah, happy 4th of July. I totally forgot about that. The British hate this day. Yeah, I don't know. I haven't spent the 4th of July in the U.S. in a while, I think. I can't remember last time I spent 4th of July in America. I remember all the times I wasn't in America, but yeah, I think I miss out on 4th of July quite often. But anywho, I'm going to toss you guys to the waiting screen for a little bit while I get some food in my tummy, and then we will jump into it. Let's see. Let's find something by Jacob. I do want something different. Let's do this one for sure. Let me cue this one up. And then I kind of want... Oh, he does have emotional here. Okay, we'll play emotional.
This shit off right. If you hold me down, then I'ma treat you nice. I need a businessman with a dope boy chain. A businessman doing dope boy things. Off the muscle, like flex, yeah, I love to see you hustle. I'm emotional, I can't let you go. I'm emotional, don't wanna see you in no hole. I'm emotional. Come on, baby, talk to me. Break it down for a chick with some money. Yeah. Come on, baby, talk to me. Talk to me. Break it down. Yeah. Bout shit, get a chick with some money. Yeah, I'm stingy with my man, like I'm stingy with my honey. Yeah. Go ahead and tell me that you love me, baby. Don't you be scared to call me. Baby boy, you should get to know me. Yeah, true, I never only, but you should try to be my one and only. You've been on me for so long. What's one more night alone? I might not pick up the phone, but I still want you to call me. Emotional, hair done, nails done, heels, I'm fly, new bad switch, I'm drippin', hair done, nails done, heels, I'm fly, new bad switch, I'm drippin'. gon' break it down for the huncho. One, she pull up, she do that stuff. Till I got on pro. We at the top. Had to cancel all the hoes. She touch that ice and now she
All right, those last two tracks are from Jacob Sampson. You can get their information by doing !Jacob. I just want to go back to some of their tracks because I really, really like their music, and I feel like we play a lot of Picto Chat. So finishing it off, we'll do a custom song that was done for the channel by Jacob titled Hell Yeah, Dude. Enjoy. See you guys in a little bit here.
Dude, we're breaking into it.
Oh, thank you. Wow.
mode.
Alrighty, we should be ready to go. Now, pardon me, because I just ate a bunch of ramen or curry really quick. So, oh my goodness. I was like, how much longer do we have on this song? And I was like, oh my goodness. And I just started shoveling that shit. Oh my gosh. How is everybody doing? Let's bring up the chat in front of me here. Greetings. Pip pip cheerio. What up, Gubna? This will always be my favorite track just because all my homies hate San Fish emote. What's kind of funny is this track wasn't at all supposed to be the final track. Jacob was like, what are some sound bites that I should use in the song that I make? And I'm like, I don't know. He's like, so what? Do I just like grab some random stuff from stream? I'm like, yeah, for now, that's fine. He's like, okay, we can always replace them later. And then he sent me that one and I was like, I like this. This is pretty good. I'm just going to use this. And then we never ever replace the sound bites ever again. So I don't think Jacob intended for those to be the final noises in there. So, but that's how it ended up. There'll always be, where in England are you? Oh, I'm in Manchester. I am in Manchester. I got to figure out how to get to London in like 2 days to meet IRI and maybe Chud Logic. I'm really happy that we'll be done with the Supreme Court thing after today because I need to not be stressing about it every day anymore. And once I'm like done with it, then I can focus on going to London and seeing London and stuff. And then, you know, onwards and upwards from there. Damn, you have a nice room. It's not my room. I'm living with a host here. But I'll pass on the compliment there. Yo, I have friends in Manchester. What? Me too. It ended up better, Giga Chad? Maybe. Oh, you're not far from me. I'm down the road in Liverpool. Yeah, I hear about you Liverpool people. I hear much about you and your soccer teams over here. Apparently, there's a good maritime museum in Liverpool. There was tons and tons of stuff I wanted to do when I came to the UK, but, you know, there are only so many things that I end up actually doing. Which is part of why, like, I cannot wait until I'm done traveling because it's like, I don't, there's this huge emotional roller coaster of arriving at a place, making a list of things that I would like to do, trying to plan those days out, and then having that plan constantly thwarted. And then at the end, looking back on it and realizing you weren't able to do like half the stuff you wanted to do. And that process becomes more and more taxing on you mentally the more and more that you're doing it. So like, it doesn't work out. And then you immediately have to start again with a new country. And then it doesn't work out. And then you immediately have to start. And like, it's the immediacy of starting over again that kind of kills it for me and saps my morale. So much so that this time I told my host, I'm like, we're making this long list of things, but the odds are that we're not going to get like any of this done. That there will maybe be like a handful of things I'm able to end up doing. And that's just how it's going to work out. Like we were supposed to go to Wales and go to Snowdonia National Park or whatever, or Snowdon National Park and see all this stuff. And then Pisco was like, hey, I have availability this weekend to do the Supreme Court thing. And I hadn't streamed in a while. So it was like, oh, well, now we'll do this. And like, you know, priorities have to be that I continue to do the streaming because it's my job and whatever. But I do feel bad for like my host who thought he was going to be driving down to Wales, and then we didn't end up driving down to Wales. There's a lot of like disappointments and anxiety and feels bad energy that comes along with traveling, ironically. And I cannot wait until I just don't have to deal with that anymore. It's tough to quantify what effect that'll have on my mental state, but like you have to multiply that by lots and lots of other things as well, like doing my tutoring or doing work outside of stream or even doing the stream, right? So lots of that, lots of disappointment going around, and I will be happy when all that is done and I have a place to live. There's a good maritime museum in Greenwich, in London. Well, I will have to tell you, I am not going to see it because there's no way in fuck I'm doing the things that I want to do in London presently in London. So the odds that I could add another thing on and successfully do that thing are incredibly slim, as I just explained. So, you know, I am getting very doomer on travel. Like, I look forward to TwitchCon EU in only so far as it means that I can stop thinking about traveling and start thinking about getting an apartment. I even jumped the gun a little bit and started calling apartment places the other night. And yeah, I'm just so very, very, very sick of travel. You need a rest country? No, I just need to have somewhere to live. Because here's the thing, if I rest like I did in Romania, all I do is look forward to when I go back. So that's not a solution anymore. It would be if I just started traveling. But again, I've been traveling for so long that I'm really, 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 as we get closer and closer to the end of July, I am just getting sick of like all of it. And I'm really just looking forward. Like it feels like I've been doing a marathon, and I got really tired, and then I twisted my ankle. And then I fell really hard and I like scraped my knees, and now those sting like a motherfucker. And there's a whole crowd watching me in like the last mile, and I have to complete this marathon. And it's really rough. And I'm just looking forward to the end of it. Because having the crowd of people, having all of you guys and stuff makes it even more difficult. And having hosts and stuff as well, unfortunately, because I feel really bad that like I don't have the energy to dedicate to them. Yeah, like I'm really, really, really not used to that. Because it used to be that when I would travel and I would hit that low point and I would be done with it, I just disappear. Like I remember in Thailand, I had this like gig doing like website work or something for this company. And when it wasn't working out and when I was getting sick of Thailand and stuff, I just like straight up told them like, I'm going to leave. And they're like, oh, that's unfortunate. What's making you think that? I'm like, oh no, like it's decided. Like on Tuesday, I'm going to leave. They're like, it is Sunday in the evening. You're going to leave on Tuesday? I'm like, yeah, I'm gone. And then I just go and I just disappear and I just be done with all of it. But I can't do that right now. So sounds like our little Booksmarts is ready to settle down and put roots down. I'm just ready to be done traveling, dude, honestly. I'm just ready to be done with that. Where are you getting an apartment? Right now I'm looking at Charlotte, North Carolina. But we will see. If Charlotte does not bear fruit in the month of July, then I don't know. I'm just really hoping that we're able to just pay everything online and then get settled in. I hope it's as easy as people keep telling me that it is, because every time that I try it, it's not. And again, there's that mental fog of being tired with everything dripping in. Is I think back to every other time I've applied for apartments and been rejected, regardless of my income. And it's like, you know, I have the voices on one side from everybody I'm talking to tell me it's so easy to apply and you can apply online and you'll get approved and whatever. And then I have all my experience on the other telling me, do not take that for granted and just assume that it won't work out. And like, so a lot of that. Where are you originally from? I'm originally from California. Books needs his library. I don't care about a library. Rental market is tough now. No, it is. So it's like, a part of my brain is just keeping in mind we may just end up going back to Mexico and living in an Airbnb or some bullshit like that. And I will tell you, if it doesn't work out, I'm going to go into caveman survival mode brain, and I will find a way to make enough money to like not be in that situation. So like, I will probably, I'm sorry, Rose Wrist, but I will almost certainly go back into doing essay writing hardcore if I am not able to find a place, because I'll need to have income to like live in a nice Airbnb, because I'm not going back to living in shitty Airbnbs. It's not happening. You got the rent application rhetoric down? yeah, we'll see. Anywho, is the cup half full or half empty? Probably half empty, but we'll see. Anywho, we should take a break from all that negativity. And get ready to talk to Pisco. Hopefully Pisco is still ready. We will see. Yeah, so just a lot of that going on. All right, let's get Pisco in this call. Hey.
Book fucker. How you doing?
Good, how are you?
Good, bro. Good. Just here chilling, back in the city. Happy 4th of July. Feels good to be an American.
Do you have any cool plans for today?
Nope. Just gonna probably catch up on some work at some point, and maybe have I don't know. Maybe I'll have a hot dog.
Hot dog is pretty American.
Yeah. It's like food you eat on July 4th, right?
I suppose so.
You know what else you eat on July 4th?
Your mom? What do you eat on July 4th? Burgers?
No. I was gonna make a reference to the law and like justice or whatever as a transition, but yours was better. How you doing, man?
I'm doing okay. I'm mentally not all there, but I am ready to be done with this. So
yeah, I mean, you've had enough. You've like gone through the oral arguments. You've gone through a majority opinion, 2 concurrences. It's a lot on the same issue.
It's not even about this. It's just like traveling and life changes and stuff. But yeah, I mean, I will be happy to be done with this as well.
Wait, so where are you now? I think you told me, but I forgot.
I'm in Manchester in England.
Oh, right.
Yeah.
You just travel the world.
Yeah.
Is that catching up on you? You want to be more stable for a little bit?
Yeah, I'm just I'm totally done with it. I want a house. Yeah, I'm over.
We all have to settle down eventually, Bookie.
Yeah.
Well, I hope things turn out okay on your house search.
Yeah, me too. Thank you. I hope they do. I've just been rejected so many times before when I tried, and now the housing market or rental market is like tight.
Fuck.
So I'm like, I hope I don't have to go back into living in Airbnbs, because that's the same stress. I'm trying to find. Are we on Roberts?
We're on Roberts. That is on the PDF, probably on page 136.
Yes.
Yeah.
Let me go ahead and bring up the thing so people could see it. There we are. Okay. I think we should be good to start. Do you have any commentary you wanted to give us before we hop into the last concurring and all the dissents?
I think we should just take stock once more where we are. Where we are is the previous 3 opinions we read represent the 5 conservative opinions who are willing to overturn explicitly Roe v. Wade. You had from the majority opinion this focus on history and tradition, and an acceptance perhaps of, for now, of fundamental rights and implied fundamental rights, and even the doctrine of substantive due process under the 14th Amendment's due process clause, but a narrow focus on what the practice is and a prizing of history, especially history as relates the 1860s, right around when the 14th Amendment was passed. That's the majority opinion's belief on Roe. They say Roe was egregiously wrongly decided. They don't take much weight in terms of the stare decisis argument that the respondents have and the government has. This is not the Mississippi government, the U.S. government. And so on the basis of saying that there's not much of a reliance interest, that the decision was egregiously decided, and that substantive due process, to the extent that it exists, needs to be really narrowly focused on history and tradition, especially in the 1860s, Roe v. Wade should be overturned. Clarence Thomas takes an extra step and says this whole line of cases is wrongly decided, egregiously wrongly decided, and that all of substantive due process, at least for the most part, needs to go. He says all of it needs to go. And to the extent that there are implied fundamental rights, and I'm not willing to say so right now, you would find it perhaps in the privileges or immunities clause of the 14th Amendment. That has some caveats too, right? It only applies to citizens, and it probably applies in the same kind of historical frame that the majority has. And Clarence Thomas says the only reason we're not overruling it right now, the cases like Obergefell, cases like Lawrence and Griswold, is because we do not have the case before us to do that. His concurrence does not get anyone else signing it, and you guys can do your own math or own rationale about why that is. And I personally think that you would have some votes to overturn some of those cases, but for, I think, probably Brett Kavanaugh. And then we read Brett Kavanaugh's concurrence, and his concurrence seems to stress more precisely than the majority opinion that this case is different than those other cases. It's different than Griswold. It's different than Lawrence. It's different than Obergefell. Again, not very convincing distinction from either the majority or Kavanaugh, but they do distinguish it. And Kavanaugh stresses that this is different than those other cases, and that it shouldn't be taken to cast doubt on that other precedent. Even if the historical rationale might apply to those cases, that you shouldn't take it that way. Kavanaugh says a lot about how he praises the other justices who came before him and understands that they were trying to do their best to come with a middle solution, but acknowledges that there wasn't a huge resolution of the issue as a result of Roe v. Wade and Casey, and that by Casey on its own terms kind of fails itself because it hasn't resolved this question that should be left to democracy. Kavanaugh repeats that, the majority repeats it. It's a big point for them. And one thing that Kavanaugh, I think the most useful thing that Kavanaugh's opinion gives us is a kind of advisory opinion on some difficult issues that might come up in the future, and it gives us some indication about where Kavanaugh is going to rule. And Kavanaugh has said, for instance, that interstate bans on abortions would probably be unconstitutional as violating your right to interstate travel. Kavanaugh also says that retroactive bans on previously had abortions would almost certainly violate either the ex post facto clause of the Constitution or the due process clause of the Constitution. And so he takes even a very conservative opinion, to be sure, but definitely a more moderate opinion than the majority opinion, or at least a more clarifying opinion on those unresolved issues, and definitely a more moderate opinion than Clarence Thomas, who says, I'll get rid of all this stuff. And so where we're left with is 5 votes to overturn Roe v. Wade. Maybe some indication practically that the other cases, just based on the composition of the court, we don't know where they're going to go. Even if they're in jeopardy, we don't know that they're going to be overruled. And some indication that the court on the really, really crazy stuff, whether that's the interstate travel bans, the retroactive abortion bans, and he even says a little something about maybe it's required, or
thanks a ton, Stixon. I do appreciate
to have an exception to the for abortion in the case of the life of the mother. With that stuff, he kind of gives us some indication that he's going to probably rule on the side of the liberals in those cases. And so that's where we're left at. Roe v. Wade is done, dead letter. We know the arguments. We know where the concurrences stand. But Chief Justice Roberts would have ruled in the same result as those other 5 justices we just talked about. but he has a different rationale. And he wouldn't overturn Roe v. Wade, at least not all of it. And so now what we're going to do is we're going to look at his concurrence and then finally the dissent to maybe give some of the abortion supporters or the Roe supporters something to hang on to.
Okay. I think that's like a good TLDR of where we have been and where we're up to right now.
Great content.
I want to also say thank you to Stixon in the chat for the 5 gifted subs. That's really, really cool. Supporting this kind of stuff, and Astos Man, which I hope means Astolfo, because I am also a man of Astolfo. They are after my heart. Supporting this content encourages me to continue to do it and makes it worthwhile, of course. And it'll also probably lead to doing more of it in the future. I really like having Pisco on here to talk to us about this stuff. And I think from everything you've told me, Pisco, it seems like it's enjoyable for you as well, which is nice.
Yeah, I like it.
I hope that, aside from doing goofy ass debate reviews and whatever, which people love, to be fair, that I could do more of this stuff. I see a future in doing stuff like this. Like I could see that like the YouTube videos and the content that we could make around like modern day events and modern politics and whatever, it's been something I've been really afraid to get into because of the space that we're in, Pisco, with all these debate people and stuff. Like I would just hate to be on like somebody's stream and then I say something stupid and a gazillion people dogpile on it. Then I have to like focus on that rather than focusing on the thing itself. But I think I need to put on my big boy pants and get over that and realize that like if that happens, but we're able to put this kind of information in front of people, that it'll be worth it. And I kind of got to suck it up and do that and do more of it.
Attitude.
Yeah.
I like that attitude for sure.
Yeah.
Although keep in mind how much work you've gone to like truly understand the opinion so far, and the debate circuit, so to speak, on Roe v. Wade has kind of a little bit run its course, right? And so by the time that you've done all the work that you've done, which I think is good, sharing, and I think in a very helpful way, these opinions to people, I do take your criticism to heart, and I think it's a worthwhile criticism, even if you say, despite it, I still have to be in this arena. It is worthwhile to note that like the debate circuit on this issue has happened, you know?
Yeah,
but
like
I still think your content is worth it to put it out, because I think it's better than that debate circuit.
And if I do a better job managerially, which is again also why I really am looking forward to living in a house, because it's like I could be like, okay, let's put every project on hold and no life this decision, and whether it's having you on or somebody else on, really marathoning it so that we could have this content done in like 2 or 3 days, and then maybe keep up then with the debate circles and see what they're talking about, and then correct the narrative where it's going off the rails, or even bringing those people on and walking through them with what the justices said versus what they said, and like being that kind of course correction is something that I would like to do. Yeah, you absolutely could do that 100%. Yeah. And then, of course, planning talks with larger people, like if I'm able to talk with Vosh and Destiny about this as well, and do a better job on the marketing front of making sure that people know that this is available and accessible and out there for people, which I'll try to do after we finish up today. Then I think, if all those ducks are in a row, then that'll make all this worthwhile, even if it's a little bit late, Yeah.
And I think they would 100% be willing to talk to you about that stuff. I think you've earned even the recent, I don't know what kind of drama you had with Steven. I heard a little bit about it, but I still think that you're respected there, and I think that Steven still likes you. So yeah. And to briefly comment on that, I fucked up. I was super hyperbolic. I said shit like, I don't think that Steven has had any good content in like 2 years.
I said mean shit, and then I walked it back because I'm like, well, clearly I don't believe that. There's been stuff I've enjoyed of his that we've reviewed even on stream, like, so I did fuck up in that, and I've been trying to be a lot more careful with the things that I'm saying, and be a lot, stop drinking on stream is a huge one, because that's, it's not an excuse for saying the things, but it is clearly like a factor in saying stupid shit. So if I could remove it, then that's one of the lessons I learned from that. Just being a lot more careful. And part of that is also doing this stuff. If I see an opportunity to talk about these court cases and it's something I could cover or bring you on to help with, then I need to be doing more of that, because that's what I think everybody ought to be doing. And to respond to JCap's chiropractor in the chat, we haven't read the Roberts opinion, but if you could repeat that question at the end, then I'll pass it on to Pisco. We could talk about that. Basically, they're asking, I don't know if you want to handle it now.
I can. So why is so the top you say Chief Justice Roberts concurring in the judgment? Why is that not concurring in part and dissenting in part? I don't actually know the answer to that question. He's definitely, to the extent that any concurrence is based on a different rationale, I would say it's a concurrence. But he's not really dissenting from any particular judgment. He's dissenting in the rationale, but dissenting in the rationale is just a concurrence, right? So my intuition, I don't know if this is right, someone in the chat can tell me if I'm wrong, because he does not side in the judgment in any way with the dissent, and because he sides in the judgment in every way with the majority, the only thing he disagrees with is the rationale, and that is the definition of a concurrence. If he had said something like, I think that I agree with the majority that the viability line in Roe and Casey should be overruled, but I think that it should be overruled and become 18 weeks, then he would be concurring in part of the judgment, I think. But even that's like a bad example. Basically, the reason is because he disagrees with the rationale, but not with the judgment, and that's it.
Gotcha. And one other little follow-up question from me. I was always under the impression that the majority opinion is a collaborative effort authored by one person, where they're taking into account both their opinions and the opinions shared by the other justices in the concurrence to deliver like a kind of full-throated thing that everybody in the majority can more or less agree with. But it seems like everybody doesn't have to agree with it, but it is still collaborative in some way. Like, what is that process like?
So if you sign on to the majority opinion, you sign on to it, right? And that's you kind of like putting your name behind it. So anyone who signs on to the majority opinion agrees with the majority opinion, at least to the like, I would say you shouldn't sign on to the majority opinion if you don't agree with the majority opinion, because the majority opinion is going to be holding.
Right.
But and oftentimes in the drafting of the majority opinion, there will be some wheeling and dealing. For instance, there are people who say that the Heller versus DC decision, that's the gun case in DC, the big famous one, that Scalia put in lines about other regulations in order to make sure he got like Kennedy's vote. And so there is, oftentimes you'll get reports of like what people had to put in order to get a majority vote on stuff, or what they had to take out in order to get a majority vote. But people will still concur to make explicit some particular point. Like Thomas will like almost always concur, I feel like, in a lot of these culture war cases, and will sometimes concur just to be like, this is how I feel the rationale is limited, or to what extent that it reaches, or whatever. And they'll do that in order to clarify something that wasn't able to get 5 votes, probably, or something that wasn't before the court. But they could still sign on to the majority opinion, notwithstanding the fact that their proviso, their little qualification, isn't in there. So yeah, the majority opinion, I would take it as the opinion of the court, even if there's like a bunch of concurrences.
Okay.
And it's a little harder when you don't have a majority opinion.
Yeah. And could we briefly make a distinction between a regular concurrence and a special concurrence?
A special concurrence?
So
Mirror's in the chat. I don't know what a special concurrence is.
Yeah. So Elijah says a regular concurrence is when the justice agrees with the court's opinion as well as its disposition, whereas a special concurrence is when the justice agrees with the court's disposition but not its opinion.
Mirror, you tell me if that's right. I've never heard of a special concurrence before, and I've maybe that's like some other terminology, or I don't know. I don't know what that is.
That's
maybe
fine.
He's right.
Well. It's from Elijah in the YouTube chat, but we can move on because we got a lot of stuff to cover today.
Yeah, let's go.
All right. So, Chief Justice Roberts concurring in the judgment. We granted certiorari to decide one question: whether all pre-viability prohibitions on elective abortions are unconstitutional. That question is directly implicated here in Mississippi's Gestational Age Act. Generally prohibits abortion after the 15th week of pregnancy, several weeks before a fetus is regarded as viable outside of the womb. In urging our review...
If there's no such thing as the Ukrainian mafia, then who is this Don Base I keep hearing about?
It's there was a TTS.
Oh, no worries.
In urging our review, Mississippi stated that its case was, quote, an ideal vehicle to reconsider the bright line viability rule, and that a judgment in its favor would not require the court to overturn. If we could briefly define the bright line viability rule, that might be good.
Yeah. So, first of all, I'll get to that. But the first thing to notice is that Roberts is narrowing what the government of Mississippi is asking for, at least initially. He's citing you see Pitt for cert I after the first sentence. He's citing the petition for certiorari. That's a petition asking for review and saying, you guys just asked whether or not pre-viability abortion, or they're all pre-viability prohibitions on elective abortions are unconstitutional. And that was what you are asking us to do. And he's going on to say, you didn't ask us initially to just review whether or not we should overturn Roe v. Wade at all, right? He's just saying that the scope of what they were asking for was whether or not the line at which you can ban abortion is viability, whether that holding is still good law or ought to be good law. And so that's why he's saying, in urging our review, Mississippi stated that in the past, they stated that the case was an ideal vehicle to reconsider the bright line viability rule. What is the bright line viability rule? Well, what's a bright line rule? A bright line rule is something that's easy to follow and that it's true for like all cases, right? A bright line rule for age of consent. Before age 18, at least federally, it's statutory rape to have sex with a minor, right? Because you're a minor before 18. That's a bright line rule. Another bright line rule might be your lawsuit is statute of limitations after a year. That's a bright line rule. It's a year. Now there might be some exceptions, whatever, but typically a bright line rule is like easy to follow and it's true for all, if not most cases. And so the bright line rule for viability was, before viability, you cannot ban abortion. Bright line rule. That's it. Before viability, you can't. That's the bright line rule. And that is different than saying you have a right to abortion. Saying you have a right to an abortion is, you could have a right to abortion up to 4 weeks, right? You could have a right to abortion up to 6 weeks, up to 8 weeks, up to 10 weeks, but you still have a right to an abortion. And what Roberts is saying here is, you should really think of it in kind of two ways. Do you have a right? And if you have a right, when does the interest of the state become large enough that you can ban abortion? And for the longest time, the bright line rule has been the interest of the state is strong enough to protect potential life at viability. That's the bright line rule. Before that, you have a right to an abortion that cannot be intruded upon by the state. And Roberts is saying you technically don't have to consider whether you have a right to an abortion to consider whether or not the line at which the government's interest is strong enough is viability. You could say that the line of interest for the government is back 12 weeks and you'd still have a right to an abortion. And so Roberts is focusing on the line and not the right.
Oh, okay. Okay. Also, just real quick, when we talk about bright line, it seems in every way that you're describing it and that I've read, it's meant to be super clear, but viability seems to be a fuzzy area around like 24 to 28 weeks and it's been moving. Is that still bright line?
It's a great point, right? Viability, one of the reasons why the concurrence, one of the concurrences in the Casey case was upset that they were making the viability line they were making the line of the state's interest at viability as opposed to like the second trimester framework, was because it was more uncertain, right? Viability supposedly, like, potentially as technology gets better, the line for viability will become less and less. Eventually, right? You can think of technology that's so good that a fetus is potentially liable 1 week after it's conceived. You just have to, and it's really easy to do it, right? It's viable in the sense that you have the technology to support it independent of the mother, right? Now, I don't actually know, is viability the baby or the fetus can live by itself? What does by itself mean? Like, obviously all kids need to have food and need to be taken care of. You can't just leave it to like get a job by itself. And so technology might affect what viability is. And so it's not that bright of a line at times, but it's been understood to at least be, in general terms, 22 to 24 weeks or something like that now. But you're right in saying that for any given case, viability will be different, right? For any particular baby or fetus, when it'll be successful in being able to live outside the womb, that's going to be different, right? That's going to depend on like a bunch of factors. And so if you're just taking the average viability is what they're doing, that's, maybe it's bright line for everyone else, but it doesn't follow to the individual.
Yeah. And then if we add on to that, what I believe that Alito mentioned in the majority opinion, which is that this could depend upon many factors, including the availability or accessibility of healthcare services, or, how good those healthcare services are in a given area, that could also affect this. But yeah, it seems like there's some fuzzy area around that. But,
yeah, it's a good observation. Yeah.
So continuing. Today, the court nonetheless rules for Mississippi by doing just that. I would take a more measured course. I agree with the court that the viability line established by Roe and Casey should be discarded under a straightforward stare decisis analysis. That line never made any sense. Our abortion precedents describe the right at issue as a woman's right to choose to terminate her pregnancy. That right should therefore extend far enough to ensure a reasonable opportunity to choose, but need not extend any further, certainly not all the way to viability. Mississippi's law allows a woman 3 months to obtain an abortion, well beyond the point at which it is considered late to discover a pregnancy. I see no sound basis for questioning the adequacy of that opportunity. But that is all I would say, out of adherence to a simple yet fundamental principle of judicial restraint. If it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. What is he saying here?
Okay. So he is stating in the previous paragraph that viability doesn't make sense, that line. And really what the previous precedent is talking about and what it should be getting at is notice. That as long as you have notice of the baby, or sorry, the fetus, that once you have that notice, and they say, what does he say? Like 12 weeks should be enough time. That is good enough amount of time for you to have an abortion. And that is before the viability of like 24 weeks or 22 weeks or whatever that is. Now, after having said that, he goes on and says, but that is all I would say out of adherence to a simple yet fundamental principle of judicial restraint. So all he would say is that he would overturn the viability line. He wouldn't say anything more than that. If it is not necessary to decide more to dispose of a case, then it is not necessary not to decide more.
Okay.
So You only decide the things that you have to decide as the court. And we can decide, then it is necessary not to decide more. So it's not a optional rule, is what he's saying. If you can decide a case on narrow grounds or broad grounds, you have to decide it on narrow grounds. That's what he means by saying, if it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. You do not have any discretion in going with a broad overruling if you can overrule it narrowly. And he's saying doing anything more is like judicial overstepping. So let me give you an example. Let's say that you can decide this particular case, by saying that there was no jurisdiction for the federal courts to hear this case. That's the ground you would decide it on instead of overturning Roe v. Wade. Right. If there was like, oh, you filed this improperly, or we should never have granted you this particular party because this party, for whatever reason, it wasn't viable under standing doctrine to bring this claim. You're going to decide it on those narrow grounds, and you're not going to decide it by overturning Roe v. Wade. And so this is kind of the same thing. If you can decide this case by getting rid of the viability line, which you can, right? He's correct that this law would stand under his analysis, and it would be a narrower analysis than what the majority does. That's why the majority spends so much time at the beginning of the opinion saying we had to do this, that we had to overturn it, because everyone was saying that to overturn the viability line was to overturn Roe v. Wade. That's why they spent all that time at the beginning. But Roberts is saying you didn't have to do that. You could have just ruled by saying viability overturned instead of saying viability and the right is overturned.
Okay, makes sense. And to clarify, would this fall under what is called an institutionalist?
Yeah, I think you would characterize it that way. That it's a principle of judicial restraint. He's worried about the institution of the court. Roberts is, because I think Roberts sees the bigger picture. Roberts sees that there may come a day when the court is just in such disregard that people start just like not obeying its orders. He's worried about that. I think he's worried about court packing and worried about all that stuff. And he's worried not about this case in front of him, but about whether or not the court will survive. And so that's why I think he's more likely to come on these like in favor of stare decisis in a particular analysis. Although keep in mind, he just said that he thinks a straightforward application of stare decisis would not lead you to maintain the viability line, but he's more likely, I think, to see those doctrines, to accept them. Certainly this principle of judicial restraint, which is to decide cases on the narrowest possible ground.
Okay. So continuing here on that fundamental principle of judicial restraint, Roberts goes on to say, perhaps we are not always perfect in following that command, and certainly there are cases that warrant an exception, but this is not one of them. Surely we should adhere closely to principles of judicial restraint here, where the broader path the court chooses entails repudiating a constitutional right we have not only previously recognized, but also expressly reaffirmed, applying the doctrine of stare decisis. The court's opinion is thoughtful and thorough, but those virtues cannot compensate for the fact that its dramatic and consequential ruling is unnecessary to decide the case before us. Section 1. Let me begin.
I just want to say everything that follows, I think, from Roberts is probably going to be true. But his conclusion, as you'll see, I think is just stupid. You'll see in a second, but keep going.
You're putting on your polygamist hat. Becoming
sorry,
Mormon.
That's my polemicist hat. Yeah, you're right. Not polygamous.
Let me begin with my agreement with the court on the only question we need to decide here, whether to retain the rule from Roe and Casey that a woman's right to terminate her pregnancy extends up to the point that the fetus is regarded as viable outside the womb. I agree that this rule should be discarded. First, this court seriously erred in Roe in adopting viability as the earliest point at which a state may legislate to advance its substantial interest in the area of abortion. Roe set forth a rigid three-part framework anchored to viability, which more closely resembled a regulatory code than a body of constitutional law. That framework, moreover, came out of thin air. Neither the Texas statute challenged in Roe nor the Georgia statute at issue in its companion case, Doe v. Bolton, included any gestational age limit. No
pause.
Okay.
So in Roe v. Wade, they adopted this trimester framework, but they didn't have to in Roe v. Wade because Roe v. Wade didn't ban all abortion at any time in Texas, right? That the Texas statute and the Georgia statute. And so what Roberts is saying here is this viability line, this is dicta. It wasn't necessary to, just like it's not necessary right now to rule on whether or not to overturn Roe and Casey in order to decide that case. Roe did not need to set forth a three-part framework for abortion to decide the case in Roe v. Wade. All they needed to decide was that you had a right to an abortion, and they could have decided and so this law has to be overturned. And then later on, when a proper case was before was before the court, they would then decide what the framework should be. But because the Texas and Georgia law didn't have any time where it was okay to have an abortion, you didn't need to decide what the metes and bounds of that doctrine was. Notice it's kind of like a waste of judicial resources, right? Like you're going to wait for there to like pass a law and then you talk about it. Why don't you just give the rule now? But that's kind of how courts operate to some extent, right? Courts are not supposed to give advisory opinions, at least in the United States. The federal courts in the United States are not supposed to give advisory opinions. They're supposed to decide cases and controversies that are before them. And what Roberts is saying is Roe versus Wade broke that rule by setting forth this viability line and this framework.
Yeah, and that's why if you'll hear a lot of these concurring opinions point back to it more closely resembled a regulatory code than a body of constitutional law, that's what they're talking about, is like the case before them didn't outline some like restrictions that they then piggybacked off of to make comments on. Instead, they came up with this kind of restriction framework kind of out of the blue or out of thin air. They came up with it on their own rather than talking or commenting on some law that already existed, and that's problematic for a lot of the justices, it seems like. And
the notion that it looks like legislating, right? You get that again. This looks like a regulatory code rather than a body of constitutional law.
Yes. So continuing here, no party or amicus asked the court to adopt a bright line viability rule. And as for Casey, arguments for or against the viability rule played only a de minimis role in the party's briefing and in the oral argument.
Pause there. Now let's talk about Casey.
Yeah.
For a second. Casey was not even a case about an abortion ban. Casey is a case about a bunch of regulations on abortion in Pennsylvania that didn't ban it, right? They didn't ban abortion. It was a spousal like notification regulation. There was a 24-hour waiting period. There were all these different regulations that people were saying was like sort of infringing on their right to have an abortion. But at no point did you need to address the line at which an abortion ban is constitutional in Casey, because that case is just about the regulations, the 24-hour waiting periods, the things that aren't bans, the non-ban regulations.
You can ignore the sub.
And so what Roberts is saying is like in Roe versus Wade, you didn't need to decide this framework and the viability line. And in Casey, you definitely didn't need to decide it. And you know, it wasn't even argued in Roe versus Wade, and it was barely argued in Casey, and it wasn't even at issue in Casey.
Continuing. What is de minimis?
de minimis means like slight, right? Like it's only like a small part. It's only like, it's not a relevant or significant amount of time. If I like if I push you, right, a little bit on the subway, some people might say that I've committed a battery on you, right? And by the letter of the law, I might have committed a battery on you. But you might say that the harm that I committed on you was de minimis. It was just a little, it was slight. It's a Latin phrase, which just means like a tiny bit.
Gotcha. Continuing, it is thus hardly surprising that neither Roe nor Casey made a persuasive or even colorable argument for why the time for terminating a pregnancy must extend to viability. The court's jurisprudence on this issue is a textbook illustration of the perils of deciding a question neither presented nor briefed. As has been often noted, Roe's defense of the line boiled down to the circular assertion that the state's interest is compelling only when an unborn child can live outside the womb, because that is when the unborn child can live outside of the womb.
This kind of circular reasoning is everywhere in these abortion opinions. Guess what? Oh, sorry, this is my polemicist hat. This is my a polemicist. Yeah. So in the majority opinion, they're like, the reason why the reason why abortion is different than these other rights is because abortion deals with potential life, and potential life. So like, why does potential life start at conception as opposed to somewhere else? They don't decide it. And so in some ways it's just circular. You're just saying because potential life starts here, you're able to regulate it. And it's a little bit of a circular loop there as well. And a lot of these abortion discussions kind of have the same thing. But this is kind of like dead to rights. If your point is that you can regulate abortion after viability because that is when it can live outside the womb, and your rationale is because that is when the unborn child can live outside the womb, it's not really convincing unless you were to say like that matters because X or Y. Yes, it's a problem. Circularity is a problem in a lot of abortion discussions, but Roberts is kind of dead to rights on this one.
Gotcha.
Casey and Roe should do a better job at explaining why viability matters. But in order to do that, you have to say something like what you have to get into the abortion debate.
Yes.
Right? You got to get into the abortion debate, and none of these people want to do that. And in order to say it, you have to be saying something like consciousness is there, or because that's when you're a human life, right? And that's what these opinions are. They don't want to be getting into that. But when they try to put limits on that, it's following the patterns of the abortion moral debates. But they're just not saying it. And that's why you're seeing the circularity, because no one wants to have a discussion about the morality of abortion and to decide finally when human life begins or ought to begin on some grounds. But unfortunately, if you don't decide that, you're just left with circularity.
Yes. And I'm happy you mentioned that, because that was going to be my follow-up, is like, well, it seems like they're making a comment on when life would begin by defining when the state should be interested in that life, because the life will begin when that life can exist outside of the womb. And if it's possible to do that, then that all of a sudden becomes a life that the state would have interest in. And furthermore, when they're stating things like they hope that this closes the debate on the topic and heals that wound for the nation, they seem very confident that determination that they've made, is exactly that, a determination on when life begins that the legal system can follow and hopefully people can latch on to for their arguments and stuff, which didn't end up coming to pass.
Yes, it's so true. And unfortunately, all of these arguments are proxies for the abortion argument. So is the majority opinion here. The majority opinion says we're not just doing the abortion debate, but by saying that abortion is different than other rights because it deals with potential life, you are saying that at conception, that's when like something important happens, it's a mess. It's a mess. It's a really hard moral question, and it's, I think, almost impossible to deal with it legally unless without addressing the issue. Because if it really were a human life, book smarts, and people thought of it as such, people would behave so differently. They wouldn't be saying something like, well, as long as the woman has no, like, you wouldn't say what Roberts is saying right now. As long as you have notice in like 12 weeks, you can kill a kid. What the hell?
Yeah.
And so people's implicit decisions about when the line is or whatever that is, like, it's showing their hand. They don't want to talk about it, but underlying it all is, I don't care about this thing at 12 weeks, but I do care about it at 24 weeks or after 12 weeks. That's like really what's at issue here, I think.
Well, to put on your polemicist hat for a second, then, would your opinion be that, like, this shouldn't be something that the Supreme Court is deciding then?
No, I in a perfect world, I would want a legislature to decide almost everything, right? In our system, given how, when I say federal in this context, I'm saying where state governments have a lot of power, even though that seems oxymoronic. It's not a unitary government, given that we have a federal government that divides power, and where so much of our population, I think, is like this reactionary base. I think that it really just is a question of institutional competency. Who do we trust to decide these questions? And you could have that same fear about the Supreme Court deciding it about anything. You have it about race. You could have it about a lot of these very intimate matters. I think the Supreme Court, in our country's context, we trust it to decide a lot of very important questions related to race and morality. Even the court does not want to, like, say that it's doing that. It does do that. Do I have a problem? Do I have a problem with the court deciding it the way it did? No, because the court had already decided the contraception question before, and had already decided the sterilization question. And for me, I think if we're okay with the court doing that stuff, it follows along abortion. Now, you could say, I don't want the court deciding the sterilization question and the contraception question, but then, like, say it with your chest and say all that stuff has to go. If you're not willing to say all that stuff has to go, then, like, don't make an institutional competency argument that I don't want the Supreme Court deciding it, because clearly you're okay with the Supreme Court deciding contraception. What? But abortion's too much? I'm okay with the court deciding sterilization, and I'm okay with the court deciding contraception, but I am not okay with deciding abortion. That to me doesn't make sense. So, you know, given the limits on our judicial system, on our federal judiciary, given the limits on the Supreme Court, the power of the other branches to curtail the Supreme Court if they want, I'm okay with the court drawing rules for individual rights, because I'm not that fearful. I don't think they're that powerful if push came to shove. Like, they're powerful right now, but if push came to shove, the political branches can boss the Supreme Court around, is my opinion.
Yeah, and historically, to borrow Vash'ism, it would seem like we have all of the examples that seem to be in your favor, that, like, really, if any of the branches just decided they weren't going to listen to it, they, in practice, it seems like they definitely could.
We listen to the Supreme Court because we want to, be almost like consensually, because we consent to their opinions, and people could just stop doing that, and governments could just stop doing that. And what's the court going to do? The court relies on the executive branch to, and state governments and people in the right positions listening to them when it matters. And so I'm not, like, that scared of the court being like, you must now give your liver over in this, like, perfect utilitarian world or something. I'm not scared of that.
Yeah. Continuing on here, 20 years later, the best defense the viability line the Casey plurality could conjure up was workability. Although the plurality attempted to add more content by opining that it might be said that a woman who fails to act before viability has consented to the state's intervention on behalf of the developing child, that mere suggestion provides no basis for choosing viability as the critical tipping point. A similar implied consent argument could be made with respect to a law banning abortions after 15 weeks, well beyond the point at which nearly all women are aware that they are pregnant. Continuing here. The dissent, which would retain the viability line, offers no justification for it either. This court's jurisprudence since Casey, moreover, has eroded the underpinnings of the viability line such as they were. The viability line is a relic of a time when we recognized only two state interests warranting regulation of abortion: maternal health and the protection of potential life. That changed with Gonzalez v. Carhart. There, we recognized a broader array of interests, such as drawing a bright line that clearly distinguishes abortion and infanticide, maintaining societal ethics, and preserving the integrity of the medical profession.
Let's talk about Gonzalez v. Carhart real quick. That was a case in which I believe there was a federal ban on a particular abortion procedure. It's like dilation and evacuation. One of those abortion procedures, which they said was too barbaric or something. And they upheld the federal law banning that procedure. And so why is he talking about this? He's doing stare decisis analysis. He's saying, on the one hand, it was wrongly decided, right? He's not saying that it's unworkable. He says that it is like somewhat workable, but recent developments in the law have undermined it. That's one of the factors for stare decisis. And like it's doing a lot of work for him right now. And so he cites Gonzalez v. Carhart. He cites that it's a stupid line to draw, that it didn't need to be decided at the time. These are all kind of factors in his stare decisis analysis for why we should overturn it. You know, if something was the pivotal holding of the case that needed to be decided, maybe you'd be more willing to overturn it, or less willing to overturn it. If something is just dicta, it's not as binding, right? It's not a binding precedent. If it's been undermined over the course of years, then it's like, less important to our everyday lives. And so this is kind of a stare decisis analysis. Yeah.
The viability line has nothing to do with advancing such permissible goals. And then he cites Gonzalez blurred the line firmly drawn in Casey between pre-viability and post-viability abortions. Consider, for example, statutes passed in a number of jurisdictions that forbid abortions after 20 weeks of pregnancy, premised on the theory that a fetus can feel pain at that stage of development. Assuming the prevention of fetal pain is a legitimate state interest after Gonzalez, there seems to be no reason why viability would be relevant to the permissibility of such laws. The same is true of laws designed to protect the integrity and ethics of the medical profession and restrict procedures likely to coarsen society to the dignity of human life. Mississippi's law, for instance, was premised in part on the legislature's finding that the dilation and evacuation procedure is a barbaric practice, dangerous for the maternal patient and demeaning to the medical profession. That procedure accounts for most abortions performed after the first trimester, 2 weeks before the period at issue in this case, and involves the use of surgical instruments to crush and tear the unborn child apart. Again, it would make little sense to focus on viability when evaluating a law based on these permissible goals. In short, the viability rule was created outside of the ordinary course of litigation, is and always has been completely unreasoned, and fails to take account of state interests since recognized as legitimate. It is indeed telling that other countries almost uniformly eschew a viability line. Only a handful of countries, among them China and North Korea, permit elective abortions after 20 weeks. The rest have coalesced around a 12-week line. The court rightly rejects the arbitrary viability rule today. And again, we have that reference of foreign governments.
And I think it's a little bit disingenuous, just a little bit, because apparently those other countries in Europe and whatever, they have a lot of exceptions to make abortions for all practical purposes available beyond 12 weeks. So they keep repeating it. It's a good line for them, whatever. We all hate North Korea. It is indeed telling that other countries almost uniformly eschew a viability line. Before that, he says his summary, right? The viability rule was created outside the ordinary course of litigation. So they didn't need to decide it. That was the point. It's wrong. It's egregiously wrong, right? It's always been completely unreasoned. And it fails to take into account of states' interests since recognized as legitimate. So developments in the law have caused the viability rule to be undermined. That's Gonzalez v. Carhart mainly, to show that there's other interests here that would justify a ban, and viability has nothing to do with that. And so that's kind of his stare decisis analysis to say this line is stupid.
And in section 2, none of this, however, requires that we also take the dramatic step of altogether eliminating the abortion right first recognized in Roe. Mississippi itself previously argued as much to this court in this litigation. When the state petitioned for our review, its basic request was straightforward. Quote, clarify whether abortion prohibitions before viability are always unconstitutional. The state made a number of strong arguments that the answer is no. Arguments that, as discussed, I find persuasive. And it went out of its way to make clear that it was not asking the court to repudiate entirely the right to choose whether to terminate a pregnancy. Quote, to be clear, the questions presented in this petition do not require the court to overturn Roe or Casey. Mississippi tempered that statement with an oblique one-sentence footnote intimating that if the court could not reconcile Roe and Casey with current facts or other cases, it should not retain erroneous precedent. But the state never argued that we should grant review for that purpose.
Pause.
Oh, go ahead.
Why didn't they say that?
I wonder.
When do you think it could?
Maybe because it would make it tougher for their case. I don't know.
It might. When do you think this litigation started?
Ooh, that I have no idea. 2020.
When do you think this law was passed?
Oh, I don't know. I thought that the issue came up in like 2020.
The Mississippi legislature passed the law in 2018.
Uh-huh.
Who was alive in 2018?
Ginsburg, right?
Bingo, bingo, bingo. So what happened was a member of the Supreme Court died. A member of the Supreme Court who was willing to maintain Roe v. Wade, Ruth Bader Ginsburg.
Mm-hmm.
And in this litigation, once she died and a new justice was put upon the Supreme Court, all of a sudden, the arguments change. Now the main argument is overrule it entirely. What do you think about that?
Well, it would seem they weren't forthcoming in their initial statements. It seems like they were being very prudent in the way that they're wording things to the court when they didn't think it could go in their favor.
Yeah, I think it. Yes. Now it seems cynical. Would you do it if you were a lawyer in this case? Be like mindful of who's on the Supreme Court? Of course you would.
Yeah.
I'm not saying what they did was wrong in the sense that like you shouldn't have done that and you should have be unaware of who's on the court, but it really goes to show you that Ruth Bader Ginsburg's death and the ascension of Amy Coney Barrett, that changed things significantly. And if Ruth Bader Ginsburg hadn't died, we'd live in a different world.
Yeah, this case would have probably gone very differently. Does that also mean that the amicus curiae or whatever, the friend of the court briefs also came afterwards from the other states asking that they overturn Roe?
I believe that this, the petition to the Supreme Court was in summer of 2020. So I think that's June 2020. And when does Ginsburg die? Oh, did she die before that? Hang on one thing. Oh no, she died September 2020. I was about to be like, oh wait, I'm in trouble. No, I think I'm right. I think they had their petition to the Supreme Court, I think in June of 2020. Yeah. Here we go. Mississippi petition its appeal of the Fifth Circuit decisions to the Supreme Court in June 2020. Ruth Bader Ginsburg died September 2020.
Okay. And I like that he's noting this as well. Instead of leaning heavily into what was being asked, he questions how that ask was changed over time, because the other justices referenced numerous times how many of the states had asked them to overturn Roe and Casey, and didn't at any point mention this critical detail about how the course of things had changed, which we're going to get more information about in the next paragraph here. So it continues. After we granted certiorari, how do I pronounce that again?
Certiorari.
Certiorari.
People pronounce it differently. You could say cert too, if you just want to. After we granted cert, people would understand that completely.
Okay. After we granted cert, however, Mississippi changed course. In its principal brief, the state bluntly announced that the court should overrule Roe and Casey. The Constitution does not protect a right to an abortion, it argued, and a state should be able to prohibit elective abortions if a rational basis supports doing so. The court now rewards that gambit, noting 3 times that the parties presented no half measures and argued that we must either reaffirm or overrule Roe and Casey. Given those 2 options, the majority picks the latter. This framing...
So what Roberts is saying here is remarkable. You lied to you lied to us. You came to the Supreme Court and we granted cert for one question, and the minute we granted cert, you changed your arguments and we're rewarding it.
Oh, that's a good point. I don't know what the ethics are on that or whatever. Like, if you grant the cert for one reason and then they change their reasoning in the middle, are you allowed to just operate off of that changed reasoning when it's not the reasoning that you accepted the case for?
There have been cases before, and I don't know if Mira's still in the chat or there's a lawyer in the chat who can confirm or deny, but there's a procedure which you can dismiss as improvidently granted a case if it comes to be like, we shouldn't have granted it because your arguments aren't
actually what you are presenting or something like that. So there are methods to dismiss the case if things change dramatically, but the truth is the court can just point to the footnote where they said, like, then you should also overturn the case if you find that our arguments doesn't suffice. They can point to that footnote and be like, they did technically argue that in their petition and we did technically grant it, and so technically it was before the court. And so on the technicality of everything, I think the majority could have said it was like all above board, right? But it's not in the spirit of what their argument was at the petitioner stage. Yeah, Mira says they could have digged it. Dig is dismissed as improvidently granted. They could have digged it, but that was not jurisdictional. To say it's not jurisdictional means like they don't have to dismiss it. They would have to dismiss it if there were some like law that said they couldn't hear the case, or if like they lied in a way that they like didn't have jurisdiction anymore. But this is not a jurisdictional question. It's one about it's like deference to the Supreme Court and its discretion, and when are we going to hear the cases and when are we not, and ultimately who's in charge of that but the 5 justices on the Supreme Court.
Gotcha. This framing is not accurate. In its brief on the merits, Mississippi in fact argued at length that a decision simply rejecting the viability rule would result in a judgment in its favor. But even if the state had not argued as much, it would not matter. There is no rule that parties can confine this court to disposing of their case on a particular ground, let alone when review was sought and granted on a different one. Our established practice is instead not to, quote, formulate a rule of constitutional law broader than is required by the precise facts to which it is to be applied, which I feel like brings us back thematically to his criticism in the Roe decision initially, right? Like,
yes. The same reason why Roberts criticizes Roe and Casey for deciding the viability line when they didn't have to is the same reason that he's admonishing the majority opinion. You didn't have to decide this.
Gotcha. I also love that he doesn't need to repeat that thesis statement over again. All of his reasoning seems to like thematically point back to what he brought up in the beginning, which is like good writing that I'm appreciating from Roberts here.
Yeah. I think you don't like Clarence Thomas's writing style.
No, not at all.
And a leader can be a bit repetitive too. But also keep in mind, this is a concurrence. And so concurrences, even though Clarence Thomas was a concurrence, concurrences can be more prose, if that makes sense, more conversational, and can take liberties to be less formulaic in some sense. The majority opinion has responsibilities to like reiterate oftentimes, although oftentimes they don't too, depending on the author. So it's a good criticism, I think, but also always keep in mind that this is a concurrent opinion, so maybe Roberts would behave differently if it were a majority opinion, but just leaving it out there.
Gotcha.
Gorsuch, NJ Palms in your chat, Gorsuch's writing, he finds I think Gorsuch also has a very appealing writing style. If you ever read an opinion of his,
I already know that I do like Gorsuch's writing. And I know that the chat continuously is bringing up the recent EPA case. I think it's like EPA versus West Virginia or something like that, where they feel like that's an advisory opinion and whatever. Just because it's outside of the scope of the current review, I don't want to talk about that too much. I just really want to focus on this one.
I haven't read it either. I just know the result. Yeah.
So that's going to be tough. And I've only heard snippets from the news and stuff, so I wouldn't be any better at commenting on it. Continuing here, following that fundamental principle of judicial restraint, we should begin with the narrowest basis for disposition, proceeding to consider that a broader one, if necessary, to resolve the case at hand. Sorry, I butchered that. We should begin with the narrowest basis for disposition, proceeding to consider a broader one only if necessary to resolve the case at hand. It is only where there is no valid, narrower ground of a decision that we should go on to address a broader issue, such as whether a constitutional decision should be overturned. And then he cites Federal Election Commission versus Wisconsin Right to Life. And then he says, declining to address the claim that a constitutional decision should be overruled when the appellant prevailed on its narrower constitutional argument.
There's kind of like two canons, or maybe there's just one, but there's a narrow canon, and then there's like the Constitution. There's canons related to, when I say canon, I just mean like rules of construction, rules of how you deal with cases. There's a canon related to constitutional issues that you don't decide the constitutional issue if you can decide the statutory issue, right? Or if you can decide the jurisdictional issue. You don't do things you don't need to, and especially you don't do things you don't need to with respect to the Constitution.
Okay.
And Mira, you can tell me if constitutional avoidance. Yeah, that's it. Nice job, professional idiot.
Okay, that's making sense to me. And again, fitting kind of thematically maybe into being against Roe for similar reasons, I think. But here, there is a clear path to decide.
Keep in mind, and that one, that would not be the, I guess in some sense you could say it's an avoidance doctrine, but it would be more that you didn't have to decide the viability line. But you did need to decide the constitutional issue in that case on the right aspect, but on the line issue, that you're correct that they didn't need to decide that.
Okay. Here, there is a clear path to deciding this case correctly without overruling Roe all the way down to the studs. Recognize that the viability line must be discarded, as the majority rightly does, and leave for another day whether to reject any right to an abortion at all. And then he points to a plurality opinion in Webster v. Reproductive Health Services, saying rejecting Roe's viability line is rigid and indeterminate, while also finding no occasion to revisit the holding of Roe, that, under the Constitution, a state must provide an opportunity to choose to terminate a pregnancy. Continuing here, of course, such an approach would not be available if the rationale of Roe and Casey was...
Can I pause real quick?
Yeah, sure.
Just to give you a little. So I was just double checking to make sure this is true. The Webster decision that Roberts cites here is a decision before Casey. This is in '89, and Justice Blackmun, writing in dissent, there was not a majority there to overturn Roe v. Wade yet, but you can see that the writing was starting to be on the wall, that there was more conservatives and more conservatives were coming on the Supreme Court who did not like Roe v. Wade and who were willing to overturn it, and they lacked a vote to overturn Roe v. Wade entirely. That's why he said in the plurality opinion. Justice Blackmun, who wrote Roe, stated in the plurality that he feared for the future of the right of abortion, and that a chill wind blows, that the right is in serious danger. This is in '89, and he was right.
Jesus.
And so that dissent, if you read the dissent, it's like, holy crap. You get chills.
Gotcha.
You get chills reading it and where you are now. But yeah, I just wanted to mention that.
Interesting. Okay, so all the way back then, we're seeing these problems start to brew.
Yep.
Of course, such an approach would not be available if the rationale of Roe and Casey was inextricably entangled with and dependent upon the viability standard. It is not. Our precedents in this area ground the abortion right in a woman's right to choose. Holy shit. There are so many. Can you read this part?
Yeah. See Carey versus Population Services International. So this was a case applying. This is a case, I think, about contraception, but he's quoting right to choose from this opinion, Carey, I believe, and that it describes that's a Supreme Court opinion which describes the holdings in Roe as about the right to choose. And then he cites Maher versus Roe, and says Roe, which is a case, I think, about abortion funding. Someone can tell me if I'm wrong with that. Where they either it's abortion fund. I think it's abortion funding. Someone tell me if I'm wrong. I think Maher versus Roe is about abortion funding, and he gives another parenthetical where it says Roe and other cases recognize a constitutionally protected interest in making certain kinds of important decisions free from government compulsion. And so then he cites again from Maher, another quote from Maher. So let me just highlight from Carey to the semicolon.
Oh shit!
From Carey to the first semicolon there. Before Maher, there's a semicolon.
Here, yes.
So from Carey, see Carey down to right before Maher.
My brain. Okay, I think it's just all this.
So go up, but go up to Carey.
Okay.
That is one citation. That is one citation where the parenthetical he has is citing Roe and Griswold in the opinion. So he's saying, Carey said that the underlying foundations of the holdings in Roe and Griswold versus Connecticut was the, quote, right of decisions in matters of childbearing. That's one quote from Carey.
Yes.
Then he cites Maher. Maher says essentially the same thing, that it's about decision making. And then he cites Maher again. That's what the id cite is for. Id. Roe did not declare an unqualified constitutional right to an abortion, but instead protected the woman from unduly burdensome interference with her freedom to decide whether to terminate her pregnancy. Webster. Roe protects the claims of a woman deciding for herself whether or not to abort a fetus she is carrying. Gonzalez. A state may not prohibit any woman from making the ultimate decision to terminate her pregnancy. So this is a big string cite. It's a big string cite because it's a very important point. The string cite is basically saying, what is the right at issue? Is the right at issue bodily autonomy? Is the right at issue privacy? And what Roberts is saying here, and this is actually something I agree with Roberts, is that it's about decisional, autonomous freedom about whether to have a child or not have a child. I totally agree with Roberts here. That is, I think, the best way to see the right is a decisional right, not as a bodily autonomy right. Because I think a bodily autonomy right, it's that is infringed all the time. Vaccine mandates, policies with respect to health that all the time, imprisoning you. Those are all kind of, I guess, getting at your bodily autonomy. We never thought of it as like an individual right to have your body free from the state. I don't think that that's the best way to see Roe v. Wade. And so he's having this string site to emphasize that what's at issue in Roe and Griswold and all these cases is a decisional right. And he has to provide a lot of support for that. And that's why he cites Supreme Court precedent from Carey, Maher, Webster, Gonzalez. All these cases are from spanning an era, right?
Yeah.
From the 70s to the 90s, or 80s and 90s to early 2000s. So that's his support for this big idea about characterizing what Roe, Griswold, and all these cases are about. Not about privacy, about decision-making with families.
Gotcha. And this is a huge refutation of what we saw in the majority and in the other concurring opinions, because their focus was a lot on the viability standard, that Roe and Casey seemed all hinged on the viability standard, whereas he's saying that wasn't the reasoning here, and that hasn't been the reasoning in all these different cases.
Okay, separate two things in your mind. One is the viability line. Mm-hmm. That is, when can the government intrude upon a right if it exists? And the other question is there a right? So one is there a right? And two, if there's a right, when can the government intrude upon it? The viability line is getting at, assume that there's a right. When can the government get rid of it? The majority opinion says there's not even a right at all. And so he already says, Roberts already says that he agrees with the majority that the line if there is a right, when can the government intrude upon that right? He agrees with the majority that it's not viability. But in this holding, he is emphasizing that what's at issue in Roe and Casey is not related to viability, because what's at issue in Roe v. Wade and Casey is this decisional freedom, and that decisional freedom, you can still have that decisional freedom before viability. And that's why he's emphasizing that.
That makes a lot more sense.
Yeah.
And to circle back to these other cases, so in Carey v. Population Services International, the Supreme Court invalidated a New York law prohibiting the advertisement and display of contraceptives to consumers. Yeah. And in Maher v. Roe, it looks like it was about
abortion funding.
Yeah. The Connecticut Welfare Department issued regulations limiting state Medicaid benefits for first trimester abortions to those that were, quote, medically necessary. And Susan Roe challenged the regulations and sued Maher, the commissioner of the social services in Connecticut. So that's a TLDR on those two. Okay. So continuing here.
If that is
the basis for Roe, Roe's viability line should be scrutinized from the same perspective, and there is nothing inherent in the right to choose that requires it to extend to viability or any other point, so long as a real choice is provided. Okay. To be sure, in reaffirming the right to an abortion, Casey termed the viability rule Roe's central holding. Other cases of ours have repeated that language, but simply declaring it does not make it so. The question in Roe was whether there was any right to abortion in the Constitution. How far the right extended was a concern that was separate and subsidiary, and, not surprisingly, entirely unbriefed. Okay.
He's repeating that, remember?
Yeah.
So he's saying that wasn't part of... People keep saying that Roe's central holding was viability, but they're wrong.
Okay. He's doing a good job.
And Casey was wrong. He's saying that the Supreme Court was wrong. He just said it was a central holding, or they just said it was a central holding, but they're wrong.
Gotcha. I like this perspective. The court in Roe just chose to address both issues in one opinion. It first recognized a right to choose to terminate a pregnancy under the Constitution, and then, having done so, explained that a line should be drawn at viability such that a state could not prescribe abortion before that period. The viability line is a separate rule fleshing out the metes and bounds of Roe's core holding. Applying principles of stare decisis, I would excise that additional rule, and only that rule, from our jurisprudence. The majority lists a number of cases that stress the importance of the viability rule to our abortion precedents. I agree that, whether it was originally holding or dictum, the viability line is clearly part of our past precedent, and the court has applied it as such in several cases since Roe. My point is that Roe adopted two distinct rules of constitutional law. One, that a woman has the right to choose to terminate a pregnancy, and two, that such a right may be overridden by the state's legitimate interests when the fetus is viable outside the womb. The latter is obviously distinct from the former. I would abandon that timing rule, but see no need in this case to consider the basic right. The court contends that it is impossible to address Roe's conclusion that the Constitution protects the woman's right to an abortion without also addressing Roe's rule that the state's interests are not constitutionally adequate to justify a ban on abortion until viability. But we have partially overruled precedents before, like in United States v. Miller, Daniels v. Williams, Batson v. Kentucky, and certainly have never held that a distinct holding defining the contours of a constitutional right must be treated as part and parcel of the right itself. Overruling the subsidiary rule is sufficient to resolve this case in Mississippi's favor. The law at issue allows abortions up through 15 weeks, providing an adequate opportunity to exercise the right Roe protects. By the time a pregnant woman has reached that point, her pregnancy is well into the second trimester. Pregnancy tests are now inexpensive and accurate, and a woman ordinarily discovers she is pregnant by 6 weeks of gestation. Almost all know by the end of the first trimester. Safe and effective abortifacients, moreover, are now readily available, particularly during those early stages. Given all this, it is no surprise that the vast majority of abortions happen in the first trimester. Presumably, most of the remainder would also take place earlier if later abortions were not a legal option. Ample evidence thus suggests that a 15-week ban provides sufficient time, absent rare circumstances, for a woman to decide for herself whether to terminate her pregnancy. Section 3.
That footnote is just him repeating and saying, like, but the majority says no one wants that approach. Neither side wants that approach. I want something that no one else wants. But he's like, we don't care. Like, we don't just listen to the litigants. Right. And also, the petitioners are the ones who change their mind about what this case is about. And so, who cares? Gotcha.
Section 3. Whether a precedent should be overruled is a question entirely within the discretion of the court. In my respectful view, the sound exercise of that discretion should have led the court to resolve the case on the narrower grounds set forth above, rather than overruling Roe and Casey entirely. The court says there is no principled basis for this approach, but in fact it is firmly grounded in basic principles of stare decisis and judicial restraint. The court's decision to overrule Roe and Casey is a serious jolt to the legal system, regardless of how you view those cases. A narrower decision rejecting the misguided viability line would be markedly less unsettling, and nothing more is needed to decide this case. Our cases say that the effect of overruling a precedent on reliance interests is a factor to consider in deciding whether to take such a step, and respondents argue that generations of women have relied on the right to an abortion in organizing their relationships and planning their futures. The court questions whether these concerns are pertinent under our precedents, but the issue would not even arise with a decision rejecting only the viability line. It cannot reasonably argue that women have shaped their lives in part on the assumption that they would be able to abort up to viability as opposed to 15 weeks.
Yeah, so this point is in, like, there are a lot of hard questions here. There are questions here about stare decisis. There are questions here about reliance interests with respect to abortion. You wouldn't have to answer any of those questions if you just took my approach. Like, no one's arguing that women are living their lives differently based on the knowledge of having the abortional right as between 15 weeks versus 22 weeks, 23 weeks. Now, he just says that in conclusory fashion, but you can understand his intuition there. How many people who are relying on their abortion rights are relying on their abortion rights being 22, 23 weeks as opposed to 15 weeks? How many people have even like considered that the marginal effect of that increase in time between 15 and 22, 23? At some level, the gap probably matters enough to people, but he's saying that since most people have their abortions way before that, it probably isn't a huge reliance interest, in my opinion.
Yeah, and I see somebody in chat saying stare decisis is the weakest argument in favor of upholding Roe, in my opinion. Like,
It's the strongest.
Yeah, like, it's just such a huge part, it seems like, of what the court does and how courts operate more generally, that it seems like it's a good place to start. And I like the way that Roberts has approached it and is avoiding this black and white thinking and like kind of tying one arm behind your back because of what the litigants in this case have asked for, or pretending that there's an ultimatum that doesn't exist, that you would have to throw out the baby with the bathwater, no pun intended, with Roe here. I don't know. I like, maybe initially before I had read this, I may have thought that, but I also didn't know a lot about stare decisis or the interpretations of it before reading this. So
yeah, I'm really curious what Notre Dame, not to pick on you, but why do you think it's the weakest argument besides it? Can you say why it's the weakest argument without bringing up Plessy and without bringing up previous times that the court has overruled opinions before? Assume that I agree with you that you often have to overturn previous decisions. Can you say why this particular stare decisis argument is bad in Roe v. Wade?
Yeah, and ideally don't bring up the so many better arguments in your opinion. We just want to focus. Oh, I don't know anything about anything.
Yeah, like okay. I think that it's people will say things like stare decisis is very weak for Roe v. Wade, but you can have that opinion, but like why? You can't just be like, well, it's weak because of Plessy and Brown versus Board of Education. That's literally conservative propaganda that's trying to convince you that we think that we should never overturn cases. Of course, this is my polemicist hat, by the way. Of course, you should sometimes overturn cases. You have to apply the analysis. Even Roberts, in overdoing the viability line in this case, he goes into a stare decisis analysis. He mentions developments in the law. Gonzalez v. Carhart. He mentions how that those previous cases, they weren't explicit holdings of Roe v. Wade and Casey because they didn't have to decide them. There are reasons why he gives, besides the fact that it's just wrong, right? Robert certainly thinks the viability line is wrong. That's a starting step for saying that I should overturn it. He wouldn't overturn it if it was right, but it's not enough that the viability line was wrong. It was wrong and it wasn't a central holding. It was wrong and it's been undermined by developments in the law. And so when you say that the stare decisis argument is very weak for Roe, not just the viability line, the actual holding of the right of abortion under Roe, you have to have a really good argument, because guess what? The argument's actually really, really strong the other way around. Think about, there's no developments in the law that have undermined Roe. There have been no developments in, the factual circumstances since Casey and now are exactly the same as they were back in the day. The rule from Roe v. Wade and Casey is very workable. You can't ban it before viability. That's a workable rule. The courts have applied it. It's a little bit harder. The undue burden standard is a little bit harder, but not with respect to the central holding of Roe and Casey. And there's a huge reliance interest on behalf of society in knowing that there's an abortional right. And so those are all factors that we consider in stare decisis. Now you can say that you better have comebacks for each of the things I said. If I said there have been developments in the law, you should be like that. Sorry, there have been no developments in the law. You should be able to point to developments in the law that have undermined Roe v. Wade. If I say there's been no development to the facts, you better point to some facts that say, abortion isn't needed anymore. Or, there's been riots in the country because of abortions. If you say it's not workable, you better explain why it's not workable. Okay? It's not enough just to be like, whatever, it's memes, I don't really know, because people are spreading this stare decisis bullshit, and it's annoying. And when we get into the dissent, you'll see why the stare decisis argument is so strong. Sorry, I don't mean to go after you, Notre Dame. I'm sure you're just, you're not. I'm not expecting you to be a lawyer or anything like that. Just be careful with those statements, because it's actually a very, very strong stare decisis analysis without saying that you never overturn cases. I don't know if can you hear me?
My bad. Yeah, to just jump in here and close off this chapter. So to be Noter's lawyer here for a second. So when they say something like there are so many better arguments to make, my understanding is they don't really understand stare decisis, and that's kind of admitted by themselves. And in one of their last comments, where they say, "I think I just disagree with the concept of the Supreme Court," or "I think I just don't think that just because the court decided something, it should be just accepted as law." It sounds like you just don't understand stare decisis very well, which isn't like a dig on you. I didn't really before we started reading this. And so for that reason, I think we should be very careful in what we're saying. If you're going to throw something out, throw it out because it doesn't make sense to you, and just be clear about that, because then we get the full context of what you're saying. So like, when I talk about the right to privacy and I'm talking about my problems with it, I cite that like, well, if you're trying to pull a right out of an interpretation across 5 or 6 different amendments, to me, that seems on its face less strong. And that way there can be corrective information that's given to me. It's not just a statement that I objectively think it's like a weak argument or a weak right or whatever. Then somebody can step in, see where I left off on my understanding, and then fill me in on the rest. But I mean, we've seen here that the stare decisis thing is a two-sided coin. On the one hand, it's talking about how we should follow precedent generally, and that's a huge point of the courts. But on the other, it also, you can look through case law to see instances where you overrule that. And that's the flip side of the coin. You should be encouraged to follow precedent. But if you think that the precedent was incorrect, here are generally the steps in the framework that we would use to evaluate whether or not it was incorrect and whether or not we should go against stare decisis. And so if we're ever talking about that, I think we need to keep that in mind, that there's two sides to this coin, and it doesn't mean that we always follow it. And we're going to get that from Roberts here, the gazillion cases where they go against, a prior ruling and why, you know what I mean? So,
yep. And you said it precisely correct. Unless your opinion is stare decisis doesn't matter, you should always follow precedent, right? Those are the opposite ends of the world, right? You always follow precedent, or you don't ever have to follow precedent. Unless you're one of those two camps, you have to be ready to apply the factors. Otherwise, you're just begging the question in a way. But sorry to make a meal of it.
Yeah, and the final thing, to just respond to one more chatter who says, well, more charitably, I would say they disagree with the doctrine of stare decisis rather than don't understand it. I don't think that's an either or. I think that's an and statement. They don't understand stare decisis and they disagree with it. And of the two things, I think the non-understanding the thing you disagree with is way more remarkable than that you disagree with it, right? Because like, I would start there. Okay, well, if you don't understand the thing, I don't really care what your opinion on it is, because at base, you just don't understand it. So whatever misconceptions you hold about the idea, that's going to be the starting place from which you based whether you agreed with it or disagreed with it. That's kind of like the problematic root from which the opinion grows up. And I think that's where a lot of my focus goes. But anywho, continuing here, which I think is in support of its holding, right? Mm-hmm. In support of its holding, the court cites 3 seminal constitutional decisions that involved overruling prior precedents: Brown v. Board of Education, West Virginia Board of Education v. Barnett, West Coast Hotel Company v. Parrish, etc. The opinion in Brown was unanimous and 11 pages long. This one is neither. Barnett was decided only 3 years after the decision it overruled, 3 justices having had second thoughts, and West Coast Hotel was issued against the backdrop of unprecedented economic despair that focused attention on the fundamental flaws of existing precedent. It also was part of a sea of change in this court's interpretation of the Constitution, quote, signaling the demise of an entire line of important precedents, a feature the court expressly disclaims in today's decision. None of these leading cases, in short, provides a template for what the court does today.
It's such a good line from Roberts, what he just wrote. It also was a part of a sea change. He's talking about West Coast Hotel. Mm-hmm. And a doctrine of cases that I mentioned to you before called the Lochner era cases.
Yes.
And those cases having to do with the right to contract, this fundamental right to contract. And the court in that case
was destroying a whole line of important precedent that had been built on it. And it was doing so on purpose because it said this was wrongly decided. In other words, it was kind of doing what Clarence Thomas is asking for, right? But what Roberts is saying is that you're expressly saying that Griswold and all these other cases are different, and you're not doing what they were doing in West Coast Hotel. They were getting rid of that doctrine, but you say that you're claiming onto that doctrine. And so how can you say that like you maintain that doctrine, but just take out this little part of it and say that therefore, and like it's more, you're more apt to overturn a case if its foundations are shaky and its foundations have been undermined. But the court, according to Roberts, is explicitly saying that those foundations of Roe v. Wade have not been shaken at all, you know? And so that's what's so frustrating too, is it seems so difficult from my perspective to be able to pick out Roe v. Wade and Casey and then at the same time claim that nothing else is disturbed. Even in the stare decisis analysis, I think it just goes to show it's a little disingenuous that of course these other cases are implicated. Polemicist hat off. Sorry.
Gotcha. And to NJ Palms in the chat, the number of times I've heard stare decisis is bad or judicial review is bad in the last couple of weeks is too damn high. Yeah, I'm just starting to realize as we get people in the chat, because I honestly, I've tried to watch some of the panels and stuff on this topic, and I become so frustrated with it having read this that I tune out, because it's like it doesn't take a Pisco in here to see the problems with what some of these people are saying. It literally just takes reading the opinions in a lot of these cases. So it really upsets me to see that happening. Like Roberts here, if you were to read this, you would have a much better understanding of stare decisis than you probably would reading or watching any of these panels on the topic or anything like that. So I've been pretty tuned out of it. And it's sad to hear that people are speaking so strongly about stuff that they simply don't understand, but that's the way of things, I suppose. Continuing here, the court says we should consider whether to overrule Roe and Casey now, because if we delay, we would be forced to consider this issue again in short order. There would be turmoil until we did so, according to the court, because of existing state laws with shorter deadlines or no deadline at all. But under the narrower approach proposed here, state laws outlawing abortion altogether would still violate the binding precedent. And to the extent states have laws that set the cutoff date earlier than 15 weeks, any litigation over that time frame would proceed free of the distorting effect that the viability rule has had on our constitutional debate. The same could be true, for that matter, with respect to legislative consideration in the states. We would then be free to exercise our discretion in deciding whether and when to take up the issue from a more informed perspective.
This is stupid, in my opinion. Polemicist hat back on. Okay, well, let me do the real analysis step and then my polemicist. So Roberts is saying like Roberts is saying that the majority opinion is saying that we have to overturn now, because if we don't, like, we're just gonna have to face this issue again in like 2 seconds, because we have all these state rules that have shorter deadlines, and so we might as well just peel off the Band-Aid right now. And Roberts is like, no, because why? Because like we might be in a better position, and there might be different laws at that time, and they might have time to like amend their laws in the time that we hand down this decision that's more narrow. I just think it's totally incoherent. Like I really don't understand this argument about, if that these laws exist somewhere, why wait, you know?
Mm-hmm.
Now I can understand why you'd want a rule that said viability overturned, but not this other stuff. But if Roe versus Wade is just going to get overturned in a year, why does it matter that it's now versus a year, other than you're buying yourself time? But that's not really what the court should be doing, like buying yourself time, I think. So to me, it's just like weird that you would delay the inevitable.
And To me, at least, it feels like he is very adamantly stating that we should keep the right defined, but it feels like in the definition of that right, when we're considering that on the flip side, there are restrictions on that right, at some point you would have to be drawing some lines or litigating between states on where that line would be. You know,
it would come up in like it would be up for the Supreme Court very, very quickly. Jay Cap says it matters because it would give women notice, and women who had abortion appointments already are now screwed. Jay Caps, you had a draft opinion leak like a month plus ago. You had more notice than we knew this was coming. Anyone who's paying attention knows this is coming. The draft opinion was major United States news. Now maybe you think like, okay, this concurrence was written without the knowledge that the draft opinion was coming, and so maybe that explains it. But we live in the real world, right? And we shouldn't write these opinions and pretend that the draft didn't happen. You know, that's just my opinion.
Sure. And again,
and also most people don't pay attention. Like, what does that mean though? This abortion ban would still be in place in the places where it exists, and you would still have uncertainty leading up to where the court's going to decide on the exact the right to have an abortion. I don't know. I just think if people aren't aware now, why would they be aware in whatever amount of time? I just think that that's a little silly. That's my opinion.
Fair enough. And before we continue to argue with the chat, I will continue.
Oh, sorry.
No worries. So we're on the last part, his conclusion. He states, both the court's opinion and the dissent display a relentless freedom from doubt on the legal issue that I cannot share. I am not sure, for example, that a ban on terminating a pregnancy from the moment of conception must be treated the same under the Constitution as a ban after 15 weeks. A thoughtful member of this court once counseled that the difficulty of a question, quote, admonishes us to observe the wise limitations on our function and to confine ourselves to deciding only what is necessary to the disposition of the immediate case, which would be Justice Frankfurter for the court. I would decide the question we granted review to answer whether the previously recognized abortion right bars all abortion restrictions prior to viability, such that a ban on abortions after 15 weeks of pregnancy is necessarily unlawful. The answer to that question is no, and there is no need to go further to decide this case. I therefore concur only in the judgment. And there we go. That's Roberts.
Yeah. I think it's a little bit
falls apart at the end there.
Yeah. I think it falls apart. I think he should just he should be advocating for his rule, and he should, in my opinion, be like Roe versus Wade should be affirmed. That's what I think would be a brave opinion. I think a brave opinion and the right opinion would be just be like Roe v. Wade should be affirmed. But the viability line should go away. But he doesn't do that. He wants to stick to this notion of judicial restraint, which I think only delays in a situation where I don't know that it matters that much ultimately, because the court is clear that it wants to overrule Roe v. Wade. So I don't know what good that does. That's just my take.
Yeah. It feels a bit like he was a peacemaker behind the scenes trying to give a compromise that everybody could agree to. And based on the few other cases I've read his opinion on, that seems to be more or less his position behind the scenes is like, okay, like what can we rule on in such a way that would be a compromise between what the dissent and what the concurring wants? And like, how can we find a healthy middle ground where we're doing what we ought to be doing as the court and not stepping beyond that? And that seems to be reflected in his opinion there.
The thing, Bookie, is though, like, I think that these laws people would start like enforcing those laws that are on the books, or would pass new laws that ban it before 15 weeks or ban it for all times, and then someone would sue to stop enforcement of that law. The law would very quickly get to the Supreme Court on a petition for like emergency relief or something, and the court would just like deny any motion to stay enforcement of the law. And I think the law would just go into effect, and the de facto situation would be the laws in effect because this court is clear that it wants to overturn Roe v. Wade. And so I really don't understand. Maybe there's some benefit to some women somewhere in delaying this decision as much as possible. And to that extent, I understand it. I just don't think that we're going to get more reasoned judgment for these issues that are old as dirt in the intervening years. The only reason why you would delay the judgment is to help people in situations like that. And that's not what Roberts is saying. Roberts is saying, like, we'd have more reasoned judgment. We'd, we wouldn't have the distorting effect of the viability rule. And so, like, we'd have more legislative consideration in the states. Like, no, dude, these issues are as old as dirt. And so I'll just say that we don't want, I guess he says that with distortionary effect, but I don't really think that he's explicitly saying, like, we want women to have the time to stop their abortions. And I don't think, if he said that, I would respect it more, but he's not saying that.
No. And I wish he would have added this, but I understand he won't because he doesn't think it's the topic they should be discussing at all. But like, if he were to reference some different sources or some different friend of the court briefs that were sent to him about like where that line should be drawn or when it should be drawn or whatever, then he could give us some idea of the present landscape and how developments might happen in the future to make the decision more clear if they weren't held to the standards placed by the previous two cases. But like, he doesn't do that at all. And he just implies that somehow there's going to be some change that leads them to a more enlightened decision if they're not shackled by the viability standard. But like, in lieu of any information on what direction he would go after that, I feel like it's really difficult for me to picture that in my head. And I personally don't even think he knows how that would go, just because he doesn't cite anything. But all right. Now we get to the dissent, which is written by two justices here. So how does that work? Oh, three. Okay.
Let's start with that. First of all, this is unusual. And a lot of people in the chat know when this happened before, when multiple judges sign their names on the same opinion as the writers of the opinion. Well, one example is Casey. The controlling opinion there was Justice Souter, Justice O'Connor, Justice Kennedy. And they signed together. Another case is, oh my God, I always forget this case. Where's Mirror? What's the case? Signed all their names. They
were unanimous in Brown, right?
They were unanimous in Brown, but that's different than Aaron versus Cooper. Got it. Okay. So in Aaron versus Cooper, there was this lingering question of whether or not states were free to just to nullify the Constitution, and whether or not they had to listen to the Supreme Court when it said what the law was. And every justice signed their names. It's an unheard of thing to have happened. Nearly unheard of, I would say, to the opinion, which said that you have to listen to us. I think that had to do with segregation and racial issues. Yeah, Aaron versus Cooper. Cool. But yeah, so we have three authors, Breyer, Sotomayor, and Kagan, and the unusualness of that is not lost on people.
So, like, from a functional standpoint, is this that like all three of them work on different parts? Do they each submit like a draft that they would like, and then they pick and choose what Frankenstein pieces they want to put in there? Okay.
My Discord thinks that Sotomayor was the principal author. That's what my Discord thinks.
Okay. But we don't know for sure, I would assume.
Not necessarily. Yeah.
Okay. Anywho,
it sounds a lot like Sotomayor, but they could have. I'm sure they all gave input as well.
Yeah, and I saw speculation in the chat that the snarkier bits were authored by Kagan, so it seems like there's a lot of speculation there.
I would say that Kagan is snarky, Sotomayor is impassioned, and Breyer is like practical.
And we saw that in their oral arguments as well, I think. Which, by the way, if you guys don't listen to those, even if you don't want to read these and you find them boring, oral arguments are generally like 1 to 2 hours long. Like they're plenty digestible. And I feel like they'll give you an idea of where the opinions are going to be. Like listening to those oral arguments, to me, I was like, oh, they're very clearly going to overrule Casey here. That is the direction that the majority is going here. So it's like, I don't know.
Yeah. But you heard it when Sotomayor's like, will we be able to wash the stench off this institution if we do what you ask us to do?
Yeah. The way you described all three is definitely reflected in their questions during oral arguments, for sure. But anywho, starting this, Justice Breyer, Justice Sotomayor, and Justice Kagan dissenting. For half a century, Roe v. Wade and Planned Parenthood of Southeastern Pennsylvania v. Casey have protected the liberty and equality of women. Roe held and Casey reaffirmed that the Constitution safeguards a woman's right to decide for herself whether to bear a child. Roe held and Casey reaffirmed that in the first stages of pregnancy, the government could not make that choice for women. The government could not control a woman's body or the course of a woman's life. It could not determine what the woman's future would be. Respecting a woman...
Ginsburg.
Yeah, we have a Ginsburg on the dissenting.
In my opinion, bringing notice to Ginsburg, bringing notice to the fact that we know what this is all about. You're overturning today because someone's dead.
Interesting. And hashing that out through the citations here is interesting, and it was interesting to see that with Roberts as well, and even in Alito's opinion.
That's my interpretation. Everyone's citing Ginsburg for different reasons, right? Yeah. Majority is citing Ginsburg because, look, Ginsburg agrees that this due process stuff is a little weird, and it stopped the development of the law, and you might be citing Ginsburg for principles of judicial restraint. Mm-hmm. Or you might be citing Ginsburg for saying that the government can't control what a woman's future is.
Yeah. And that selective quoting is something that you see not only here, but like speaking as an essay writer, that happens a lot in essays or in dissertations as well. You'll cite people that you could cite in a number of different ways for very different reasons. Mm-hmm. And, it's interesting to see that here as well.
And all positive, right? All positive Ginsburg. In their own way, right? And in using Ginsburg as a shield in some way.
Yeah, she clearly, everybody has respect for her in the way that they're using her quotes, whether it's to go in one direction or another. And building off of that, respecting a woman as an autonomous being and granting her full equality meant giving her substantial choice over this most personal and most consequential of all life decisions. Roe and Casey well understood the difficulty and divisiveness of the abortion issue. The court knew that Americans hold profoundly different views about the morality of terminating a pregnancy even in its earliest stages, and the court recognized that the state has legitimate interests from the outset of the pregnancy in protecting the life of the fetus that may become a child. So the court struck a balance, as it often does when values and goals compete. It held that the state could prohibit abortions after fetal viability so long as the ban contained exceptions to safeguard a woman's life or health. It held that even before viability, the state could regulate the abortion procedure in multiple and meaningful ways. But until the viability line was crossed, the court held, a state could not impose a substantial obstacle on a woman's right to elect the procedure, as she thought proper, in light of all the circumstances and complexities of her own life. Today, the court discards that balance. It says that from the very moment of fertilization, a woman has no rights to speak of. A state can force her to bring a pregnancy to term, even at the steepest personal and familial costs. An abortion restriction, the majority holds, is permissible whenever rational, the lowest level of scrutiny known to the law.
Remember we talked about that? Rational basis review versus strict scrutiny. Rational is the lowest, and almost always it's going to pass rational basis.
And if you're interested in hearing more about that, I would highly recommend that you check out the last couple of streams we've done with Pisco. And because, as the court has often stated, protecting fetal life is rational, states will feel free to enact all manner of restrictions. The Mississippi law at issue here bars abortions after the 15th week of pregnancy. Under the majority's ruling, though, another state's law could do so after 10 weeks, or 5, or 3, or 1, or again, from the moment of fertilization. States have already passed such laws in anticipation of today's ruling. More will follow.
Pause. Everyone knew this. In other words, everyone knew this is coming, and everyone knew why this is coming.
Yeah, and we talked before, and there will be a video dropping after today's stream kind of giving a TLDR on that and talking about those trigger laws in different states. I believe it's like 26 in total, depending on how you would count that. So a lot of states, they had plans for how this case would go and how they would respond. Some states have enacted laws extending to all forms of abortion procedure, including taking medication in one's own home. They have passed laws without any exceptions for when the woman is the victim of rape or incest. Under those laws, a woman will have to bear her rapist child or a young girl her father's, no matter if doing so will destroy her life. So too, after today's ruling, some states may compel women to carry to term a fetus with severe physical anomalies. For example, one afflicted with Tay-Sachs disease, sure to die within a few years of birth. States may even argue that a prohibition on abortion need make no provision for protecting a woman from risk of death or physical harm. Across a vast array of circumstances, a state will be able to impose its moral choice on a woman and coerce her to give birth to a child. Enforcement of all these draconian restrictions will also be left largely to the state's devices. A state can, of course, impose criminal penalties on abortion providers, including lengthy prison sentences. But some states will not stop there. Perhaps, in the wake of today's decision, a state law will criminalize the woman's conduct, too, incarcerating or fining her for daring to seek an abortion, to seek or obtain an abortion. And as Texas has recently shown, a state can turn neighbor against neighbor, enlisting fellow citizens in the effort to root out anyone who tries to get an abortion or to assist another in doing so.
That's Texas's bounty hunter statute.
Yeah. Which also, very, very slight footnote, they even do something unprecedented in allowing you to seek the legal charges that were involved in taking up such a case against the person that you brought the case against, which, to my understanding from reading articles and stuff, is like unprecedented. I
wouldn't say necessarily it's unprecedented, but it's highly unusual, very litigation friendly. And it's the opposite of the quote unquote American rule. The American rule is you pay for your own damn lawyers. But yes, there's fee shifting provisions in that law, and it's highly unusual.
Gotcha. The majority tries to hide the geographically expansive effects of its holding. Today's decision, the majority says, permits each state to address abortion as it pleases. That is cold comfort, of course, for the poor woman who cannot get the money to fly to a distant state for a procedure. Above all others, women lacking financial resources will suffer from today's decision. In any event, interstate restrictions will also soon be in the offing. After this decision, some states may block women from traveling out of state to obtain abortions, or even from receiving abortion medications from out of state. Some may criminalize efforts, including the provision of information or funding to help women gain access to other states' abortion services. Most threatening of all, no language in today's decision stops the federal government from prohibiting abortions nationwide, once again from the moment of conception and without exceptions for rape or incest. If that happens, the views of an individual state's citizens will not matter. The challenge for a woman will be to finance a trip to New York or California.
Not to New York.
Oh, my bad. A trip not to New York or California, but to Toronto. Whatever the exact scope of the coming laws, one result of today's decision is certain: the curtailment of women's rights and of their status as free and equal citizens. Yesterday, the Constitution guaranteed that a woman confronted with an unplanned pregnancy could, within reasonable limits, make her own decision about whether to bear a child, with all the life-transforming consequences that act involves. And in thus safeguarding each woman's reproductive freedom, the Constitution also protected the ability of women to participate equally in this nation's economic and social life. But no longer. As of today, this court holds a state can always force a woman to give birth, prohibiting even the earliest abortions. A state can thus transform what, when freely undertaken, is a wonder into what, when forced, may be a nightmare. Some women, especially women of means, will find ways around the state's assertion of power. Others, those without money or childcare or the ability to take time off from work, will not be so fortunate. Maybe they will try an unsafe method of abortion and come to physical harm, or even die. Maybe they will undergo pregnancy and have a child, but at significant personal or familial cost. At the least, they will incur the cost of losing control of their lives. The Constitution will, today's majority holds, provide no shield, despite its guarantees of liberty and equality for all.
Pause. Notice the difference between the dissent's view of the state and the majority's view of the state. The majority says, you want to give the freedom back to the states. Let the states decide. And so the distinction for the majority is states versus federal constitutional rule by the Supreme Court. The distinction between the dissent, the dichotomy that the dissent presents, is not state versus federal. The dichotomy that the dissent presents is state versus individual. Give the choice to the people to decide for themselves if they want an abortion. That's how they view the different, I would say, levels in this democracy. This is not a choice for the state to have. It's a choice for the people to have. And that's how you can have this opinion seem, the dissenting opinion seem like a appeal to democracy as well as the majority. They're just talking about different things. The dissent is referencing the right of the people to have their abortions if they want them, if they choose. And the majority is saying the right of the states to decide for themselves whether or not to allow it.
Which is a completely different frame to view things through. Yeah. And no one should be confident that this majority is done with its work. The right Roe and Casey recognized does not stand alone. To the contrary, the court has linked it for decades to other settled freedoms involving bodily integrity, familial relationships, and procreation. Most obviously, the right to terminate a pregnancy arose straight out of the right to purchase and use contraception.
Absolutely true.
In
Griswold and Eisenstadt.
Yes. In turn, those rights led, more recently, to the rights of same-sex intimacy and marriage in Lawrence v. Texas and Obergefell v. Hodges. They are all part of the same constitutional fabric, protecting autonomous decision-making over the most personal of life decisions. The majority, or to be more accurate, most of it, is eager to tell us today that nothing it does casts doubt on precedents that do not concern abortion, which is interesting. That's a quote from Thomas, given what he said. But
yeah, the majority. That's why she's saying, or they're saying, the majority, or to be accurate, most of it. And she cites the majority that says it does not cast doubt on the precedent. But C anti, right? CF compare. Anti at 3, Thomas J concurring, advocating the overruling of Griswold, Lawrence, and Obergefell.
Oh, okay. There's my inability to read the citations coming to a head. So, okay. Now I understand. Anti
means like the site, a site above, and CF means compare. or anti the decision above, right? The majority opinion above.
Okay.
So compare that to this, to the majority opinion to the concurring opinion at page 3.
Okay, that's cool that you could do that. But how could that be? The lone rationale for what the majority does today is that the right to elect an abortion is not deeply rooted in history. Not until Roe, the majority argues, did people think abortion fell within the Constitution's guarantee of liberty. The same could be said, though, of most of the rights the majority claims it is not tampering with.
Boom. True. Logical. True. Right? True for gay marriage, true for gay sex, true for contraception. That's why I say when people are like, it's not undermining those rights. This is just clean logic that no one can disagree. That the center of the opinion on the merits of Roe with a majority has to do with whether or not it's deeply rooted in history. That's the basis of the opinion. You can't say that that's the basis of the opinion and then you apply that rationale to these other rights and you come to the same conclusion. And so if you're following the logic of the majority opinion, absolutely all of these other rights have to go away if you're following the logic. And the dissent notices it, as does Justice Thomas. And so that's why they're saying, how can this be, right? How can it be that it doesn't affect it? The lone rationale for what the majority does today is that it's not deeply rooted in history. That same could be said, though, of most of the rights the majority claims it is not tampering with. And then you can continue. Sorry.
Gotcha. I had to read this in my head a few times to know how to say it right. The majority could write just as long an opinion showing, for example, that until the mid-20th century, there was no support in American law for a constitutional right to obtain contraceptives. So one of two things must be true. Either the majority does not really believe in its own reasoning, or if it does, all rights that have no history stretching back to the mid-19th century are insecure. Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under threat. It is one or the other.
So true. So true. And I've been saying this for weeks. You heard me say it on Destiny that that Alito's draft opinion was disingenuous. The reason is it's obvious. Either they're telling you the truth, and then therefore all of these rights are at risk, even though the court says they're not at risk, or at least it doesn't expressly say that, but it says it doesn't undermine it. Or the court's lying about its reasoning. And the court's not lying about its reasoning.
Yeah.
And so this is just, to me, is just logical, like a logical truth. That's how on point I think it is. That I almost think that to not accept this makes you irrational. I almost think that.
Yeah, or just very narrowly viewing quotes and stuff, because you can easily quote everybody but, Thomas and saying that it's not going to do this. It almost makes me wonder if they were like kicking Thomas under the table when he was writing this. Like, bruh, knock it the fuck off. They're going to be scared we're coming after all this other stuff. You got to be less transparent about that. One piece of evidence on that score seems especially salient: the majority's cavalier approach to overturning this court's precedents. Stare decisis is the Latin phrase for a foundation stone of the rule of law. The things decided should stay decided unless there is a very good reason for change. It is a doctrine of judicial modesty and humility. Those qualities are not evident in today's opinion. The majority has no good reason for the upheaval in law and society it sets off. Roe and Casey have been the law of the land for decades, shaping women's expectations of their choices when an unplanned pregnancy occurs. Women have relied on the availability of abortion both in structuring their relationships and in planning their lives. The legal framework Roe and Casey developed to balance the competing interests in this sphere has proved workable in courts across the country. No recent developments, either law or fact, have eroded or cast doubt on those precedents. Nothing, in short, has changed. Indeed, the court in Casey already found all of that to be true. Casey is a precedent about precedent. It reviewed the same arguments made here in support of overruling Roe, and it found that doing so was not warranted. The court reverses course today for one reason and one reason only: because the composition of this court has changed. Stare decisis, this court has often said, contributes to the actual and perceived integrity of the judicial process by ensuring that decisions are founded in the law rather than in the proclivities of individuals. Today, the proclivities of individuals rule. The court departs from its obligations to faithfully and impartially apply the law. We dissent.
Oof. Can I pee? I'll be right back.
Yeah. So lots of interesting things here. So one notable stylistic difference is in the citations being used here. Well, I think that we saw a lot more citations both to historic texts and to other laws and other cases in the dissent's opinions, and here we have that happening a lot less. And when it does happen, it seems to particularly pertain to what we're kind of discussing here, the legal history of this ruling in particular. That's not to say that one is better than the other. I'm just kind of a little bit of a brain fart because my essay brain is going to be looking at the way that things are written. And it's a lot more powerful. It's focused a lot on women's rights. I think that Roberts was as well in part, or I would say in whole, he's mostly focusing on a woman's right to have an abortion in the first place, but with a lot of caveats and stuff like that, like believing that the initial, bounds of what Roe allowed for in terms of abortions through that pre-viability rule didn't make a lot of sense, because he probably has a particular issue with the viability line and just wants that gone. But the reality is that with the court as it is now, it's unlikely that he would get that to happen. And even if he did, like we've mentioned with Pisco, it's not like it wouldn't come up again. And if it does come up again, I wonder how willing he would be to draw that line, or even how he would draw that line, right? Like, I guess there is a part of me that's interested in how he would make a determination on that, because we just see no reasoning about that from his perspective. He shits on the limitations that Roe put on things and doesn't think that we should put limitations, but limitations would have to be placed on it at some point, because even Robert seems to agree that there are going to be limitations on this right, and it's a question of when and how. And I have no idea how he would draw those lines. So, okay, you're back?
I'm back. Sorry.
Okay.
I do want to say, to Mirror's point in the chat, here the court is, the dissent is explicitly saying that no development has happened for the stare decisis analysis except that Ruth Bader Ginsburg has died. They are saying it explicitly. They are accusing everyone in this situation that essentially this is all just, we all know why this has happened, and it's all happened because someone died. That's what the dissent is explicitly saying. It's that's a big accusation, right? That's saying, like, that's calling the court political.
Yeah, the proclivities of individuals rule. I really like that line.
Yeah.
Yeah, I think it's put very succinctly. Okay, so starting on section 1, we start with Roe and Casey, and with their deep connections to a broad swath of this court's precedents. To hear the majority tell the tale, Roe and Casey are aberrations. They came from nowhere, went nowhere, and so are easy to excise from this nation's constitutional law. That is not true. After describing the decisions themselves, we explain how they are rooted in, and themselves led to, other rights giving individuals control over their bodies and their most personal and intimate associations. The majority does not wish to talk about these matters for obvious reasons. To do so would both ground Roe and Casey in this court's precedents and reveal the broad implications of today's decision. But the facts will not so handedly disappear. Roe and Casey were from the beginning, and are even more now, embedded in core constitutional concepts of individual freedom and of the equal rights of citizens to decide on the shape of their lives. Those legal concepts, one might say, have gone far toward defining what it means to be an American. For in this nation, we do not believe that a government controlling all private choices is compatible with a free people. So we do not, as the majority insists today, place everything within the reach of the majorities and government officials. We believe in a constitution that puts some issues off limits to majority rule. Even in the face of public opposition, we uphold the right of individuals, yes, including women, to make their own choices and chart their own futures. Or at least, we did once. Section A. Some half-century ago, Roe struck down a state law making it a crime to perform an abortion unless its purpose was to save a woman's life. The Roe court knew it was treading on difficult and disputed ground. It understood that different people's experiences, values, and religious training and beliefs led to opposing views about abortion. But by a 7-2 vote, the court held that in the earlier stages of pregnancy, the contested and contestable choice must belong to a woman in consultation with her family and doctor. The court explained that a long line of precedents founded in the 14th Amendment's concept of personal liberty protected individual decision-making related to marriage, procreation, contraception, family relationships, and child rearing and education. For the same reasons, the court held the Constitution must protect a woman's decision whether or not to terminate her pregnancy. The court recognized the myriad ways bearing a child can alter the life and future of a woman and other members of her family. At the same time, though, the court recognized valid interests of the state in regulating the abortion decision. The court noted in particular important interests in protecting potential life, maintaining medical standards, and safeguarding the health of the woman. No absolutist account of the woman's right could wipe away those significant state claims. The court therefore struck a balance, turning on the stage of the pregnancy at which the abortion would occur. The court explained that early on, a woman's choice must prevail, but that at some point the state's interests become dominant. It then set some guideposts. In the first trimester of pregnancy, the state could not interfere at all with the decision to terminate a pregnancy. At any time after that point, the state could regulate to protect the pregnant woman's health, such as by insisting that abortion providers and facilities meet safety requirements. And after the fetus's viability, the point when the fetus has the ability of meaningful life outside the mother's womb, the state could ban abortions, except when necessary to preserve the woman's life or health. In the 20 years between Roe and Casey, the court expressly reaffirmed Roe on 2 occasions and applied it on many more. Recognizing that arguments against Roe continue to be made, we responded that the doctrine of stare decisis demands respect in a society governed by the rule of law. And we avowed that the vitality of constitutional principles cannot be allowed to yield simply because of disagreement with them. So the court over and over enforced the constitutional principles Roe had declared. And they cite Ohio v. Akron Center for Reproductive Health, Hodgson v. Minnesota, Simopolis v. Virginia, Planned Parenthood Association of Kansas City, Montana, Incorporated v. Ashcroft, H.L. v. Matson, Bellotti v. Baird, Planned Parenthood of Central Montana v. Danforth, Missouri.
So a big string cite here to say what's true, which is like this principle, Roe v. Wade has been affirmed numerous times and been applied numerous times, right? And this is not even all the cases in which it's been applied in the Supreme Court, not just in the lower courts.
And out of curiosity, as an essay writer, is the style requirement that they cite things in chronological order from the most recent to the oldest?
It used to be. So Blue Book 20 had it so that you had to of the same type, right? So cases would come before like books, or cases would come before like law review articles, and then you would do things in reverse chronological order, which would be starting with the latest and going to the earliest. That is what the rule used to be. But I believe in Blue Book version 21, which is the current one, I have it right now, I think, they just say like cite it in whatever order makes sense. Someone can tell me if I'm wrong, but I remember that partway through law review, I was on my law school's law review, I had to like stop marking as incorrect the order of citations for not being in reverse chronological order.
Interesting. Okay. It probably matters.
But it's still the practice, right? It's still the practice of a lot of people to do that rule, right? And to do it in reverse chronological.
Gotcha. And it probably matters to nobody but me, but I find style guides and things to be interesting.
Yeah, it's interesting. So you'll notice before a lot of the citations are all split through semicolons. So if you see semicolons, that's how they're split up. And they usually often have signals before them. So C, for example, it means C, which means there's like an inferential step that the sentence that they gave, which so the court over and over enforced the constitutional principles. No one of these decisions actually says that thing. The decisions don't actually say, so the court over and over enforced it, but the citations are the things that do the enforcing. And so that's why you need C. C is an inferential step needed. And for example means there's more here, but we're just for the sake of just giving you a couple, we're going to just list off some of them, but there's more. So C, for example, all these cases.
Gotcha. Then, in Casey, the court considered the matter anew and again upheld Roe's core precepts. Casey is in significant measure a precedent about the doctrine of precedent, until today, one of the court's most important. But we leave for later that aspect of the court's decision. The key thing now is the substantive aspect of the court's considered conclusion that, quote, the essential holding of Roe v. Wade should be retained and once again reaffirmed.
So real quick, this is very important. Casey is a precedent about precedent, but we're not going to be talking about stare decisis. That's what they're saying. But the reason we say it is because Casey is, we have to say this, and they have to repeat it because Casey, while it is about stare decisis, it's also about the central holding. At least that's what they're arguing, right? And so, unlike what the majority would say, Casey never even considered the central holding. Casey was just about stare decisis. It's not about the merits of Roe versus Wade. You hear that a lot. Right? You hear a lot that Casey has nothing to do with Roe v. Wade, didn't really defend it that much. Dissent is saying, no. Yeah, it's a precedent about precedent, but it's also a precedent about the essential holding. And it says that it should be reaffirmed. So that's why you have that.
Gotcha. Because they want to refute that point kind of offhandedly with the quote. Gotcha.
Yes.
Central to that conclusion was a full-throated restatement of a woman's right to choose. Like Roe, Casey grounded that right in the 14th Amendment's guarantee of liberty. That guarantee encompasses realms of conduct not specifically referenced in the Constitution. Quote, marriage is mentioned nowhere in that document, yet the court was no doubt correct to protect the freedom to marry against state interference.
Pause. So recognizing that Casey is explicitly embracing implied fundamental rights in the due process clause, right? Both of those things, both that there are implied rights and that they're part of the 14th Amendment's due process clause. And unlike you remember the majority's like, the Roe majority found it in the 9th Amendment, the 4th Amendment, the 1st Amendment, the 14th Amendment, right? You remember all that stuff?
Yeah.
But dissent saying like, no, it was clear. Roe said 14th Amendment. Yeah, they also said 9th Amendment. That's another argument you could give, but they landed on the 14th Amendment, and Casey especially landed on the 14th Amendment. And so they're not, this dissent is being explicit that it's the 14th Amendment. It's not this big consolation, and they don't see a big issue in the fact that the penumbras thing is around.
And at the time, I do remember that when the dissent was talking, they were referring to the right to privacy that Roe was based on, and that they used the right to privacy argument, which needed all those different amendments. So they were taking like a very specific approach to things that would allow them to paint it as if it were based on many, many, many different amendments. Yes. So continuing here. And the guarantee of liberty encompasses conduct today that was not protected at the time of the 14th Amendment. It is settled now, the court said, though it was not always so, that the Constitution places limits on a state's right to interfere with a person's most basic decisions about family and parenthood, as well as bodily integrity. And we have a long citation here that says, similarly describing the constitutional protection given to personal decisions relating to marriage, procreation, contraception, and family relationships.
Okay. This is to get in at you. Again, you had a question like, why is Clarence Thomas asking about what the interest is? in the oral arguments, it comes up again. The court here is saying, Casey said, it's about what are these rights about? What was it about? Privacy? Is it about this, about that? And the dissent says that Casey says that it's about basic decisions about family and parenthood. It's about bodily integrity. It's also about personal decisions related to marriage, procreation, contraception, and family relationships. So the dissent is saying that Casey said, and it agrees that it's not just one thing, it's multiple things. And so Clarence Thomas doesn't like that, right?
Yeah.
He wants them to settle on one. But the dissent says Casey doesn't settle on one, and we're not settling on one either.
Yeah, and to respond to the person in the chat about ibid is an abbreviation for the Latin word ibidem, meaning in the same place, and it's used to save space when you're saying that something is in the same source.
So he's asking about between ibid and id. I only use id, but I know that I think especially some older individuals I know use ibid. I don't know that there's a specific style guide for the Supreme Court stuff, but here you can see that they're using id.
Gotcha. Especially important in this web of precedents protecting an individual's most personal choices were those guaranteeing the right to contraception. In those cases, the court had recognized the right of the individual to make the vastly consequential decision whether to bear a child. So too, Casey reasoned, the Liberty Clause protects the decision of a woman confronting an unplanned pregnancy. Her decision about abortion was central, in the same way, to her capacity to chart her life's course. In reaffirming the right Roe recognized, the court took full account of the diversity of views on abortion and the importance of various competing state interests. Some Americans, the court stated, deem abortion nothing short of an act of violence against innocent human life, and each state has an interest in protection of potential life, as Roe itself had recognized. On the one hand, that interest was not conclusive. The state could not resolve the moral and spiritual questions raised by abortion in such a definitive way that a woman lacks all choice in the matter. It could not force her to bear the pain and physical constraints of carrying a child to full term, when she would have chosen an early abortion. But on the other hand, the state had, as Roe had held, an exceptionally significant interest in disallowing abortions in the later phase of a pregnancy, and it had an ever-present interest in ensuring that the woman's choice is informed, and in presenting the case for choosing childbirth over abortion. So Casey again struck a balance differing from Roe's in only incremental ways. It retained Roe's central holding that the state could bar an abortion only after viability. The viability line, Casey thought, was more workable than any other in marking the place where the woman's liberty interests gave way to a state's efforts to preserve potential life. At that point, a second life was capable of independent existence. If the woman even by then had not acted, she lacked adequate grounds to object to the state's intervention on the developing child's behalf. At the same time, Casey decided, based on 2 decades of experience, that the Roe framework did not give states sufficient ability to regulate abortion prior to viability. In that period, Casey now made clear, the state could regulate not only to protect the woman's health, but also to promote prenatal life. In particular, the state could ensure informed choice and could try to promote childbirth. But the state still could not place an undue burden or substantial obstacle in the path of a woman seeking an abortion. Prior to viability, the woman, consistent with the constitutional meaning of liberty, must retain the ultimate control over her destiny and her body. Go ahead.
Important here that how the dissent reconciles Casey and Roe, because we know that Casey in some ways is inconsistent with Roe, right? And that Casey overturned a couple cases that affirmed Roe. What the dissent sees as those differences is only incremental differences, right? Look at the first line of that paragraph. So Casey again struck a balance differing from Roe's in only incremental ways. And so unlike the majority says, look at Casey, it overturned cases, it's totally inconsistent with Roe, it's very different, it's also doesn't care about stare decisis. That's very good optically for them. The dissent sees it very differently. The dissent says it's only different in incremental ways. It only, it modified the viability standard, it was more considerate of non-ban abortions, but the central aspect of it was maintained.
Gotcha. And if I remember correctly too, I thought there were some citations from the dissent, maybe even about how the central holding was in question, but I believe it was only from the dissent because it's the only place they could find that quote. And maybe a concurring opinion from somebody who still felt like they had problems.
Remember.
Yeah, it gets very specific.
Yeah, you're asking whether or not the majority cited the dissent or concurrence in responding to their conclusion about whether it overruled Roe.
Or the central holding
sure.
of Roe.
The central holding, yeah.
Because
it's a big question whether or not they did.
Yeah, in my shot in the dark guess would be that they reference maybe Roberts having a problem with with defining where that right starts and stops. That would be what my guess is.
Probably.
But anywho, carrying on here, we make one initial point about this analysis in light of the majority's insistence that Roe and Casey, and we in defending them, are dismissive of a state's interest in protecting prenatal life. Nothing could get those decisions more wrong. As just described, Roe and Casey invoked powerful state interests in that protection, operative at every stage of the pregnancy and overriding the woman's liberty after viability. The strength of those state interests is exactly why the court allowed greater restrictions on the abortion right than on other rights deriving from the 14th Amendment. But what Roe and Casey also recognize, which today's majority does not, is that a woman's freedom and equality are likewise involved. That fact, the presence of countervailing interests, is what made the abortion question hard and what necessitated balancing. The majority scoffs at that idea, castigating us for repeatedly praising the balance the two cases arrived at, with the word balance in scare quotes. What do they mean by this?
What scare quotes are quotes used for emphasis. So like think about, have you ever seen Dr. Evil in Austin Powers? And he's like laser, and he'll do the little air quotes. So like those are kind of like scare quotes. It's used to show like either skepticism of some kind, or that it's like a new kind of a way of looking at things that they're putting into question almost, right?
Gotcha.
And so what they're saying is the majority scoffs at that idea. They castigate us for repeatedly praising the quote balance with the word balance in scare quotes, as though it's something wrong, as though it's something that you should question, right?
It's funny that they put that in here. It's just it's very I guess snarky, to borrow from the
It's super snarky, but it's also true, like that they're interpreting, you put things in there for a reason, right? You don't put the scare quotes in there if you don't think, unless you're actually quoting. Like, it's there for a purpose, and it's there to scoff at it.
Yeah.
Right.
Yeah.
And that is true,
And this gets back to a big theme of the channel, which is rhetoric, and the different ways in which, like, the way that you're using something can deliver the message that you want to deliver, that like you can use things in very different ways. Like, I think that here in using this quote, they're like, yeah, motherfucker, it did. Like, we are praising the balance, and there was a balance struck. And as we've proven prior to this in the last like 2 or 3 paragraphs, like it very clearly was establishing a balance between these competing interests. To the majority, balance is a dirty word, as moderation is a foreign concept. Jesus Christ. The majority would allow states to ban abortion from conception onward because it does not think forced childbirth at all implicates a woman's rights to equality and freedom. Today's court, that is, does not think there is anything of constitutional significance attached to a woman's control of her body and the path of her life. Roe and Casey thought that one-sided view misguided. In some sense, that is the difference in a nutshell between our precedents and the majority opinion. The constitutional regime we have lived in for the last 50 years recognized competing interests and sought a balance between them. The constitutional regime we enter today erases the woman's interests and recognizes only the states or the federal governments.
Pause. This is really important. So the dissent here is dead to rights. For all rights that we recognize, there are always countervailing interests and interests of the states. Whether you're talking about the First Amendment, your First Amendment right, we're going to balance that in the case of time, place, and manner restrictions differently than content-based restrictions on what you say. If you have, people always get mad when you bring up the Oliver Wendell Holmes opinion or dicta there's a case called the Schneck case where it's illegal to falsely yell fire in a crowded movie theater, right? You've heard that before, right? That I don't think is an inaccurate state of the law. It probably is okay for states to say that it's illegal to falsely shout fire in a crowded movie theater. I think that's probably like okay for states to ban. People make fun of it for other reasons. But it just goes to show you that there are limits to every right. And typically the approach has been you look at what the right is at issue, you apply a level of scrutiny, right? That's what we talked about. Is it rational basis review? Is it strict scrutiny? Depending on whether or not it's a fundamental right or something like that. And then you see, well, what are the interests of the states? This court, rather than say, well, the interest is just really, we think the interest is different. They're denying that a right even exists at all because we don't want to have this, this is the dissent's kind of own portrayal of it. And so I'm sure that the majority wouldn't agree with this characterization, but the dissent is sort of saying you don't want us to have a balance because you don't like the notion of balance. You don't like the notion of weighing things against each other. And you just want to be all or nothing. Either there's an abortion right up until birth or there's no abortion right whatsoever. And rather than rework the balance in a way you think is more appropriate, like Justice Roberts wants to do, right? Rework the balance. You just want to get rid of it entirely. And it's not just this opinion. The court in recent opinions has shown a reluctance to do this kind of balancing with other rights too. Oh, and look, someone said to look at the footnotes, and they're right. So in the footnotes, they said, for this reason, we do not understand the majority's view that our analogy between the right of an abortion, the right to contraception, and same-sex marriage shows that we think the Constitution does not permit the states to regard the destruction of a potential life as a matter of any significance. To the contrary, the liberty interests underlying these rights are very similar, but only in the sphere of abortion is the state interest in protecting potential life involved. So only in that sphere, as both Roe and Casey recognized, may a state impinge so far on that liberty interest. The majority's failure to understand this fairly obvious point stems from its rejection of the idea of balancing interests in this or maybe in any constitutional context whatsoever. So they're citing the gun case. That's New York State Rifle and Pistol Association. Because in that case, the court said, we're not going to do balancing. We're not going to do traditional scrutiny analysis with guns. The only inquiry is whether or not the regulation was historically okay. And if it was historically okay, the regulation is acceptable. Otherwise, it's not. And so the court in recent weeks has been pushing away from this kind of scrutiny analysis and has been pushing more towards this very historical all or nothing approach, which you noted in when you were reading Roberts, that Roberts wasn't about the all or nothing approach. But this court seems to be more into the all or nothing approach, and that's what they're being criticized for.
Yes. And as another citation note, so when they do CF, it is a signal indicating that the cited source supports a different claim than the one just made, but that it's worthwhile to compare the two claims and assess that difference. Yeah.
Yeah. So So you would say something like, most cases show a support for some notion. See this, CF some other case, which maybe the quote there recognizes the same thing that the other sources recognize, but it comes out to a different conclusion. But the comparison between the two is somehow illuminated. So that's what CF is. Oftentimes it will be something that isn't exactly the point, but the comparison is telling.
Gotcha. And why do we have the blanks at the end of that citation before 2022?
Yeah, it's a new opinion, and so they haven't like put it into volumes yet. And so they don't actually know the page numbers yet, and they don't know the volume because they just came out this term, right? But they still want to cite it.
Gotcha.
And so that's why you have those blank spaces, and then it says slip opinion at 8 and 15 to 17. That's the page numbers of the actual opinions, because they get published in these volumes, and they're sort of continuously paginated. And so you could have an opinion at 582, and then the next opinion's at 583, and you start your pages at 583. And so that's typically the process. But a slip opinion is just individually paginated, just like this one is, right? But yeah.
Okay, gotcha. And once that case is put into a volume and is properly cataloged and whatever, will they retroactively go back to this brief and fill that in?
I actually don't. I think the answer's Mirror, help me. Is he still clear?
Such a technical question.
I don't know. I was actually just wondering that myself. I don't know. Maybe one of the other laws. Yes, they do.
Okay.
Yeah.
That makes sense.
Yeah.
But wow, what tedium. You'd have to like keep markers on here, and somebody would have to manually go in and correct the whole thing later. Interesting. Sorry, my brain gets so focused on the citation stuff, and I'm sure nobody cares.
Yeah. I care.
Awesome. Well, section B. The majority makes this change based on a single question. Did the reproductive right recognized in Roe and Casey exist in 1868, the year when the 14th Amendment was ratified? The majority says, and with this much we agree, that the answer to this question is no. In 1868, there was no nationwide right to end a pregnancy, and no thought that the 14th Amendment provided one. Of course, the majority opinion refers as well to some later and earlier history. On the one side of 1868, it goes back as far as the 13th century. The 13th century. Jesus. Why is this one written like this? It's so strange.
Because this. So remember in this majority opinion, you have this paragraph is one of the best dissent paragraphs in my opinion at like in the history of the world at calling out the hypocrisy of picking and choosing. Yeah, Palm's got it, picking and choosing your history. So in the majority opinion, they're like, look at Roe versus Wade, those idiots. They went all the way to antiquity to find out whether there's a right to abortion. But the majority opinion in the gun case, right? Mm-hmm. In the gun case, you have to read the next sentence.
Gotcha.
And basically, it'll be in the gun cases and other cases when it wants to, it'll cite back to before or it'll cite back to after. It'll cite whatever history it wants to. That's basically the sentence. Read from the start of the paragraph again, and that's basically the criticism that you're picking and choosing.
Gotcha. Okay. Of course, the majority opinion refers as well to some later and earlier history. On the one side of 1868, it goes back as far as the 13th century. But that turns out to be wheel spinning. First, it is not clear what relevance such early history should have, even to the majority. See New York State Rifle and Pistol Association v. Bruin, which is the footnote we got from before, quoting, historical evidence that long predates ratification may not illuminate the scope of the right.
So they're citing Thomas's opinion and being like, you guys just said that you're not supposed to use that history from before, but you're using it in this case.
If the early
Next
history...
line is a banger.
If the early history obviously supported abortion rights, the majority would no doubt say that only the views of the 14th Amendment's ratifiers are germane. Okay.
Read this for this parenthetical. It is better not to go back too far into antiquity, except if olden law survived to become our founders' law. And so basically they're saying like, if there was like a clear history that predates the 14th Amendment that was like abortion was a fundamental right, they would be like, it doesn't matter.
Gotcha. Second, and embarrassingly for the majority, early law, in fact, does provide some support for abortion rights. Common law authorities did not treat abortion as a crime before quickening, the point when the fetus moved in the womb, and early American law followed the common law rule.
All true.
So the criminal law of that early time might be taken as roughly consonant with Roe's and Casey's different treatment of early and late abortion.
Pause. So the CC saying is like, if the early history supported abortion rights, you would say that it doesn't matter. Second, it does support abortion rights because the early common law history was that it was not a crime before quickening, and the American law followed that at the time. And then he says, better then to move forward in time. And you can start from there.
Gotcha. And somebody mentioned to look at footnote 3, which is for the sentence, and early American law followed the common law rule. The footnote says, C.J. Moore, Abortion in America, The Origins and Evolutions of National Policy. And the quote is, I guess citation, the majority offers no evidence to the contrary, no example of a founding era law making pre-quickening abortion a crime except when a woman died. And even in the mid-19th century, more than 10 states continued to allow pre-quickening abortions. So there's that as well, I suppose.
Yep.
Better then to move forward in time. On the other side of 1868, the majority occasionally notes that many states barred abortion up to the time of Roe. That is convenient for the majority, but it is window dressing. As the same majority, plus one, just informed us, post-ratification, adoption, or acceptance of laws that are inconsistent with the original meaning of the constitutional text obviously cannot overcome or alter that text.
So, like, what the fuck? You just made an opinion stating why. So, basically, New York in, like, the 1890s or the early 20th century, one of those, had passed a law, I believe it's called the Sullivan Act, which had, like, which was like a gun ban, like a licensing scheme, which is largely in place today and was like largely overturned by this opinion. And there were other sort of licensing schemes at the same time from other states. And people are like, look, there's this history of laws that allow the kind of thing that New York is allowing now. And the majority says in that case, doesn't fucking matter. You obviously can't use the laws that are passed after the relevant text to discern the meaning of it. But now the court is citing all the fact that abortion laws, they were criminalizing abortions after the 14th Amendment was passed. And so how can you with a straight face say it doesn't matter for guns, but it does matter for abortion? That's just fucking stupid.
Gotcha. Had the pre-Roe liberalization of abortion laws occurred more quickly and more widely in the 20th century, the majority would say, once again, that only the ratifiers' views are germane.
Yeah, you wouldn't cite it unless it was good for you. That's what this is saying. It's a slam, you're basically, they're calling the majority liars. They're calling them hacks, because they are hacks. Because if it were good for them, they would cite it. If it were bad for them, they wouldn't cite it and say it doesn't matter. And everyone knows that that's what it would happen. Everyone knows that Alito would say it doesn't matter if it was bad for them. And so, I totally agree with the dissent here. I think this paragraph's absolutely devastating and absolutely true.
Gotcha. And to anybody confused, germane means relevant to a subject under consideration. So just in case you've been lost. The majority's core legal postulate, then, is that we in the 21st century must read the 14th Amendment just as its ratifiers did. And that is indeed what the majority emphasizes over and over again. And then they give a quote, the most important historical fact is how the states regulated abortion when the 14th Amendment was adopted. If the ratifiers did not understand something as central to freedom, then neither can we. Or said more particularly, if those people did not understand reproductive rights as part of the guarantee of liberty conferred in the 14th Amendment, then those rights do not exist. As an initial matter, note a mistake in the just preceding sentence. We referred there to the people who ratified the 14th Amendment. What rights did those people in their heads have in their heads at the time? But of course, people did not ratify the 14th Amendment. Men did. So it is perhaps not so surprising that the ratifiers were not perfectly attuned to the importance of reproductive rights for women's liberty or for their capacity to participate as equal members of our nation. Indeed, the ratifiers, both in 1868 and when the original Constitution was approved in 1788, did not understand women as full members of the community embraced by the phrase, "we the people." In 1868, the first wave of American feminists were explicitly told, of course by men, that it was not their time to seek constitutional protections. Women would not even get the vote for another half century. To be sure, most women in 1868 also had a foreshortened view of their rights. If most men could not then imagine giving women control over their bodies, most women could not imagine having that kind of autonomy. But that takes away nothing from the core point. Those responsible for the original Constitution, including the 14th Amendment, did not perceive women as equals and did not recognize women's rights. When the majority says we must read our foundational charter as viewed at the time of ratification, except that we may also check it against the Dark Ages, it consigns women to second-class citizenship. The Section B is going hard, dude.
That's the 13th Amendment reference, right?
Yeah.
So they're like the 1300s, right? And so it's very, very, very sarcastic here. It's saying like, basically you're saying all that we can do is check our rights as they existed at the time of the founding, except you can kind of check it against the 13th Amendment Dark Ages shit too. So super, super snarky. Basically saying that you guys are backwards in some ways, you know?
Yeah. Let me also find this. Women's voting. Is it, I think it's Switzerland? One sec. I just want to shoehorn in. There is a really, really interesting movie that you guys might be interested in on the topic of women's suffrage about women's voting in Switzerland. So women in Switzerland couldn't vote until 1971.
Oh, you're kidding?
Yeah.
I didn't know that.
And that's a country with really, really, really strong like democratic principles and stuff. And there were groups even of women who didn't think that women, they didn't think that women ought to have the right to vote for a myriad of different reasons, which the movie goes over. But like, you know, if you're in a society that tells you that women ought not to have that right and gives a bunch of different reasons for it, you'll even have people who, against their own interests, decide to support the movement against giving themselves more rights, or in this case, giving them the right to vote. So if you're interested in that, that's an interesting movie that explores that. It focuses in on these people living in a small Swiss village and about how there's this women's organization that tries and keeps all the women from thinking about having the right to vote, and about how there's this woman at the head of that organization who is a widow, who has all these particular rights afforded to her as a widow of somebody that had a lot of power, who believes that she would lose a lot of power if women got the right to vote. The women would have it less good in life if we started to move in the direction of liberalization and gave them more rights, and that women in their current position in society would be better off not beginning to embark in that direction and getting those rights and seeking equality with men. And she was really afraid of that. So, you know, this has happened in other countries as well, and it's interesting to look at the psychology of that. But there's my little random footnote from culture.
That's super interesting. Like, I think it's true not just of the issues related to women. A lot of things that you would think are like ostensibly, or people who you think are like badly affected by certain policies will nonetheless embrace them. I think of like Republicans on this a lot too. A lot of the policies of the Trump administration, I think, and or at least with respect to tax policy, like did not favor a lot of Trump's base. But perception is different than reality.
Yeah. And for anybody interested, the movie is called The Divine Order. And it was made in 2017, so it's not like it's some weird old movie. Like, it has a lot of like modern humor and stuff in it. So it's enjoyable even if you don't speak, Swiss German or whatever. Anywho, Casey itself understood this point, as will become clear. It recollected with dismay a decision this court issued just 5 years after the 14th Amendment's ratification, approving a state's decision to deny a law license to a woman and suggesting as well that a woman had no legal status apart from her husband. There was a time, Casey explained, when the Constitution did not protect men and women alike. But times had changed. A woman's place in society had changed, and constitutional law had changed along with it. The relegation of women to inferior status in either the public sphere or the family was no longer consistent with our understanding of the Constitution. Now, the Constitution protects all individuals, male or female, from the abuse of governmental power or unjustified state interference. So how is it that, as Casey said, our Constitution, read now, grants rights to women, though it did not in 1868? How is it that our Constitution subjects discrimination against them to heightened judicial scrutiny? How is it that our Constitution, through the 14th Amendment's Liberty Clause, guarantees access to contraception, also not legally protected in 1868, so that women can decide for themselves whether and when to bear a child? How is it that until today, that same constitutional clause protected a woman's right in the event contraception failed to end a pregnancy in its earlier stages? The answer...
Yeah, good. I just want to pause real quick. If they're right that the 14th Amendment should only mean what it meant in history at the time it was written, obviously, it doesn't apply to women. Right? Obviously. There's no... So you can't get around that. How do you possibly get around that conclusion? And so if that's the case, all of the 14th Amendment precedent with respect to women, that should all be overturned. Why not?
Using this reasoning, it could be applied in this same instance to take away these rights that I think nobody would agree with, regardless of what side of the abortion issue you would fall on. So continuing here, the answer is that this court has rejected the majority's pinched view of how to read our Constitution. The founders, we recently wrote, knew they were writing a document designed to apply to ever-changing circumstances over centuries. Or, in the words of the great Chief Justice John Marshall, our Constitution is intended to endure for ages to come and must adapt itself to a future seen dimly, if at all. That is indeed why our Constitution is written as it is. The framers, both in 1788 and 1868, understood that the world changes. So they did not define rights by reference to the specific practices existing at the time. Instead, the framers...
This is Breyer. This feels like Breyer.
Instead, the framers defined rights in general terms to permit future evolution in their scope and meaning. And over the course of our history, this court has taken up the framers' invitation. It has kept true to the framers' principles by applying them in new ways, responsive to new societal understandings and conditions. Nowhere has that approach been more prevalent than in construing the majestic but open-ended words of the 14th Amendment, the guarantees of liberty and equality for all. And nowhere has that approach produced prouder moments for this country and the court. Consider an example Obergefell used a few years ago. The court there confronted a claim based on Washington v. Glucksberg that the 14th Amendment must be defined in a most circumscribed manner, with central reference to specific historical practices, exactly the view today's majority follows. And the court specifically rejected that view. In doing so, the court reflected on what the proposed historically circumscribed approach would have meant for interracial marriage. The 14th Amendment's ratifiers did not think it gave black and white people a right to marry each other. To the contrary, contemporaneous practice deemed that act quite as unprotected as abortion. Yet the court in Loving v. Virginia read the 14th Amendment to embrace the Loving's Union. If Obergefell explained, rights were defined by who exercised them in the past, then received practices could serve as their own continued justification, even when they conflict with liberty and equality as later and more broadly understood. The Constitution does not freeze for all time the original view of what those rights guarantee.
Can we pause there real quick? So, this is another example which people have to deal with. At the time of the 14th Amendment's passage, nobody thought what they were doing at the time was getting rid of segregation. No one thought that. No one thought that we were getting rid of miscegenation laws. No one thought that. And so how can you have this historical approach that's so narrow to the individual circumstances that existed? Did abortion itself actually exist at the time? Rather than the underlying value inherent in the words of the 14th Amendment, which of course nowadays we recognize bans segregation and of course applies to women and bans miscegenation laws. It's not individual practices that were put into the Constitution. The Constitution is a document which is meant to endure. It was underlying values, and finding out the metes and bounds of those values is really hard. It's really hard. But to assume that it only codifies the pre-existing practices of states at the time is nonsense. You have to reject Brown under that analogy. You have to reject Loving under that analogy, and all of the cases involving women in the Equal Protection Clause. So I think that the dissent is just so right here, and the majority is so. What they're asking for, if they were brave, they would say we should overturn Brown v. Board of Education, but they won't say that.
No. Well, I mean, the other guy gets close. I mean, Thomas gets close with what he's okay with overturning, but you know, even then with his relationship in Loving v. Virginia, I don't know, that just blows me away that he doesn't see the connection there personally, but whatever.
Wait, there's someone I need to respond to this. So to be fair, Brown ruled that segregation couldn't satisfy the equality criterion. It argued Plessy was wrong because the segregation created inequality and that separate but equal was impossible, which is why the testimony with a child and adults was so important. I'm not saying that the Brown v. Board decision was interpreting the due process clause. I'm not saying that. What I'm saying is, if you're taking the approach that the only thing that matters with respect to the 14th Amendment are the things that existed at the time of the passage of the 14th Amendment, which is what this court is saying, then you have to say that they didn't think that the words that they were using was banning segregation. And under that analogy, right, it just follows logically. Either the only thing that matters is what existed at the time and what they thought the words meant, or something else might matter, and like a deeper value might matter. Unless you're going to say, well, the deeper value only matters with the Equal Protection Clause, but it doesn't matter with the Due Process Clause. Where would you get that distinction? So I think that ultimately, if you're taking the approach of the history only matters with respect to what happened at the time, that applies equally with both the Equal Protection Clause and the Due Process Clause. So I don't really see a distinction.
Mm. And they did respond to you, but I will cut it.
Yeah.
That does, I'll just finish with the last sentence. The Constitution does not freeze for all time the original view of what those rights guarantee or how they apply. That does not mean anything goes. The majority wishes people to think there are but two alternatives. One, accept the original applications of the 14th Amendment and no others, or two, surrender to judges' own ardent views, ungrounded in law, about the liberty that Americans should enjoy. At least that idea is what the majority sometimes tries to convey. At other times, the majority, or rather most of it, tries to assure the public that it has no designs on rights, for example, to contraception, that arose only in the back half of the 20th century. In other words, that is, that it is happy to pick and choose in accord with individual preferences. And then they cite Kavanaugh in the concurring here. And Thomas, which is a scary citation to make because Thomas is kind of out there. But that is a matter we discuss later. Again with this, but that we'll get on that.
Yeah. So they're going to get to the distinction between abortion and those other rights, and they're going to be,
I think, more explicit about it. But this is an important point that like the majority is saying that we're okay with picking and choosing what rights we want and what rights they don't want. But just keep in mind, the majority is doing the same thing. If their accusation is correct, their accusation is reflective of their own conduct as well, because they're picking and choosing contraception and not abortion.
Yeah, for now.
Yeah.
For now, our point is different. It is that applications of liberty and equality can evolve while remaining grounded in constitutional principles, constitutional history, and constitutional precedents. The second Justice Harlan discussed how to strike the right balance when he explained why he would have invalidated a state's ban on contraceptive use. Judges, he said, are not free to roam where unguided speculation might take them. Yet they also must recognize that the constitutional tradition of this country is not captured whole at a single moment. Rather, its meaning gains content from the long sweep of our history and from successive judicial precedents, each looking to the last and each seeking to apply the Constitution's most fundamental commitments to new conditions. I will say, I like this. We're going back again to that language of the long sweep of our history that was kind of cited, I think, in jest or whatever, making fun of them, scare quotes maybe, in Alito's opinion, I believe it was. Anywho, where were we? That is why, right?
Yeah, I think that we are. That is why Americans to go back to Obergefell.
Gotcha. That is why Americans, to go back to Obergefell's example, have a right to marry across racial lines. And it is why, to go back to Justice Harlan's case, Americans have a right to use contraceptives so they can choose for themselves whether to have children. All that is what Casey understood. Casey explicitly rejected the present majority's method. Quote, the specific practices of states at the time of the adoption of the 14th Amendment, Casey stated, do not mark the outer limits of the substantive sphere of liberty which the 14th Amendment protects. To hold otherwise, as the majority does today, would be inconsistent with our law. Why? Because the court has vindicated the principle over and over that no matter the sentiment in 1868, there is a realm of personal liberty which the government may not enter, especially relating to bodily autonomy and family life. Casey described in detail the court's contraception cases. It noted decisions protecting the right to marry, including to someone of another race. And then they put a quote, interracial marriage was illegal in most states in the 19th century, but the court was no doubt correct in finding it to be an aspect of liberty protected against state interference.
When you get these people who are like Rose stupid, like judicial usurpation of power or whatever, get them on Loving versus Virginia and interracial marriage. Get them on that and ask them what they think about that. If you're going to take this historical approach that only takes into consideration what existed at the time. Really, I mean, how many people did you get that are like, this is bullshit, it was never intended to be an abortion right, no one thought at the time, Get them on record saying they disagree with the decision on interracial marriage, because that must follow. It must follow. How else do you distinguish it?
Yeah.
Palm says it will just stay protected with equal protection, but no one thought the equal protection clause meant that.
Exactly.
It's the same thing, right? No one. It's the same argument. They're like, no one thought the due process clause meant abortion rights. No one thought the equal protection clause meant no more miscegenation.
Yep. Continuing here. In reviewing decades and decades of constitutional law, Casey could draw but one conclusion. Whatever was true in 1868, it is settled now, as it was when the court heard arguments in Roe v. Wade, that the Constitution places limits on a state's right to interfere with a person's most basic decisions about family and parenthood. And that conclusion still held good until the court's intervention here. It was settled at the time of Roe, settled at the time of Casey, and settled yesterday that the Constitution places limits on a state's power to assert control over an individual's body and most personal decision-making. A multitude of decisions supporting that principle led to Roe's recognition and Casey's reaffirmation of the right to choose. And Roe and Casey, in turn, supported additional protections for the intimate and familial relations. The majority has embarrassingly little to say about those precedents. It literally rattles them off in a single paragraph, and it implies that they have nothing to do with each other or with the right to terminate an early pregnancy, asserting that recognizing a relationship among them as addressing aspects of personal autonomy would ineluctably, is that right?
Hang on, let me get there.
I don't even know what that word means, to be honest.
Wait, where is it? After
it's C ante.
C ante, asserting that recognizing a relationship among them as addressing aspects of personality would ineluctably. Yeah, I think that's right. Unable
to be resisted or avoided, inescapable. Ineluctable. Okay.
Oh,
that's what the British. I'm unfortunately on the British version of Google, so I will have to go with that. But that is flat wrong. The court's precedents about bodily autonomy, sexual and familial relations, and procreation are all interwoven, all part of the fabric of our constitutional law, and because that is so, of our lives. Especially women's lives, where they safeguard a right to self-determination. And eliminating that right, we need to say, before further describing our precedents, is not taking a neutral position, as Justice Kavanaugh tries to argue. His idea...
Can I pause real quick?
Yeah.
I do want to get back to that, but I want to address your chat real quick. Both Val Movement, that's a funny name, and Professional Idiot. Val Movement says that's why there had to be repeated civil rights acts, but keep in mind that doesn't help you. The Civil Rights Act banned private discrimination, but we're talking about government discrimination, and that's what the Constitution protects against. And also, it doesn't address necessarily miscegenation, and it's still a constitutional rule of decision that we passed down that you're not allowed to do that as a government, to have miscegenation laws. And so you have to answer whether or not you think that was a good or bad idea. And so the civil rights acts don't really help you out there. And the Professional Idiot says it's pure cope, what he just said. So you don't have to listen to anything the Professional Idiot just said. I mean, that's just pure cope. The principle's different. What's the difference between the principle and the application? Like, really? Is that what you're saying? That there's like this concept of difference between principle and the application that somehow makes the mistake with respect to the equal protection different than alleged mistake against the due process clause? That doesn't make any fucking sense. Either what matters is the practices at the time and the understanding at the time about the scope of a constitutional provision, or it doesn't. And what you just said is pure cope.
Okay.
Pure cope.
I'm cutting you off. We're not arguing it.
No, this guy like totally pissed me off in my own Discord, and he's
then you have personal beef. You have to cut this.
Stupidity. Pure stupidity.
Shenanigans on Professor Idiot. You can't attack him anymore.
Okay.
Especially women's lives where they safeguard a right to self-determination. And eliminating that right, we need to say before, oh, wait, I already fucking read this. See, you got me lost. Okay, so I love that they just straight up name drop Kavanaugh instead of having a quote and whatever. His idea is that neutrality lies in giving the abortion issue to the states, where some can go one way and some another. But would he say that the court is being scrupulously neutral if it allowed New York and California to ban all the guns they want? If the court allowed some states to use unanimous juries and others not, if the court told the states, decide for yourselves whether to put restrictions on church attendance, we could go on. And in fact, we will. Suppose Justice Kavanaugh, Jesus Christ, suppose Justice Kavanaugh were to say, in line with the majority opinion, that the rights we just listed are more textually or historically grounded than the right to choose. What then of the right to contraception or same-sex marriage? Would it be scrupulously neutral for the court to eliminate those rights too? The point of all these examples is that when it comes to rights, the court does not act neutrally when it leaves everything up to the states. Rather, the court acts neutrally when it protects the right against all comers. And to apply that point to the case here, when the court decimates a right women have held for 50 years, the court is not being scrupulously neutral. It is instead taking sides against women who wish to exercise the right, and for states like Mississippi that want to bar them from doing so. Justice Kavanaugh cannot obscure that point by appropriating the rhetoric of even-handedness.
Neutrality, yeah. It's so stupid, Bookie, because like, how would you say that? Like, let's say that you were like, well, the Constitution, we're being neutral on miscegenation laws. We're being neutral. Like, that's not what you're asked to do with individual rights. The point about neutrality with individual rights is making sure everyone has the same rights, not saying that you don't decide on the right.
Yeah, I like one quick question on procedure. I presume that the majority opinion and concurrences are written and then reviewed before the dissent rights. Is that okay? Oh,
I'm sure that you have the draft majority opinion first. But it could change, right? Like some dissents start out as majority opinions, and then like it changes when the composition changes, or because you have like someone who changes their mind or something. So I'm sure sometimes it's different, like, but probably I'm guessing the majority opinion, they send it a draft first,
Yeah, Mirror says they all write at the same time. Then how are they able to then quote Justice Kavanaugh's concurring opinion here then?
I don't know how they would do that, Mirror. Mirror knows more than I do. I would go with him.
Like maybe they're all sharing drafts at the same time and it's like a Google Docs situation where everybody can see what everybody else is doing, but there has to be some sequential order given that they're referencing Kavanaugh here. That all happens during the editing process.
Yeah, he knows more than I do.
Gotcha. Okay. Justice Kavanaugh cannot obscure that point by appropriating the rhetoric of even-handedness. His position just is what it is. A brook no compromise refusal to recognize a woman's right to choose from the first day of a pregnancy. And wait, what does that mean? A brook no compromise refusal to recognize a woman's right to choose from the...
I don't know what that phrase means.
I don't either, but I guess it's meant to just underscore we're just straight up refusing a woman's right to choose from the first day of pregnancy. In that position, as we will now show, cannot be squared with this court's long-standing view that women indeed have rights. Whatever the state of the world in 1868, to make the most personal and consequential, that has to be intentional. They have to know that you're going to pause here, even if it's only a parenthetical. Jesus, this is written in such a funnier way than the rest of this. Holy shit.
Yeah, they're pissed.
Yeah, they are. Rightfully so. But still. Yeah. Consider first, then, the line of this court's cases protecting bodily integrity. No right in this court's time-honored view is held more sacred or is more carefully guarded than the right of every individual to the possession and control of his own person. Interesting citation here from these two, and I'm not familiar with either of the. Missouri seems to have a lot of fucking court cases involving them, but this Union Pacific Rail Company, I'm not familiar with at all.
I'm not sure I know either. Do you have the full case name?
It's Union Pacific Rail Company v. Botsford.
Do you know it, Mirror? I'm not sure.
I'm not.
Oh, I don't know. I feel like I've read Cruisin' before, but I'm not sure either.
Okay. I'm just going to read the brief syllabus. Botsford was against the Union Pacific Railway Company for negligence in the construction and care of an upper berth in a sleeping car in which she was a passenger, by reason of which the berth fell upon her head, bruising and wounding her, rupturing the membranes of the brain and spinal cord, and causing a concussion of the same, resulting in great suffering. Jesus, I don't. Okay, well, that's a niche, but okay. Anywho, I'll just continue. The quote that they give is, every adult has a right to determine what shall be done with his own body. Although I don't see how that came from that, but okay. Or to put it more simply, everyone, including women, owns their own bodies. So the court, okay, we have answered. They all start drafting.
This sounds like anti-vax, or this sounds like anti-vax rhetoric, huh?
A little bit.
A little bit, right?
But then we put restrictions in the same way we put restrictions on abortion.
Abortion.
Yeah.
Yes, right.
They all start drafting after the conference where they vote on the case. The specifics do not get finalized until the drafts are circulated.
Oh, okay.
Okay.
All right, smart.
Interesting. Or to put it more simply, everyone... Okay, I read that. So the court has restricted the power of government to interfere with a person's medical decisions or compel her to undergo medical procedures or treatments. And then they give some examples of forced surgery, forced stomach pumping, forced administrations of antipsychotic drugs. Continuing here, Casey recognized the doctrinal affinity between those precedents and Roe, and that doctrinal affinity is born of a factual likeness. There are few greater incursions on a body than forcing a woman to complete a pregnancy and give birth. For every woman, those experiences involve all manner of physical changes, medical treatments, including the possibility of a cesarean section, and medical risk. Just as one example, an American woman is 14 times more likely to die by carrying a pregnancy to term than by having an abortion. That women happily undergo those burdens and hazards of their own accord does not lessen how far a state impinges on a woman's body when it compels her to bring a pregnancy to term. And for some women, as Roe recognized, abortions are medically necessary to prevent harm. The majority does not say, which is itself ominous, whether a state may prevent a woman from obtaining an abortion when she and her doctor have determined it is a needed medical treatment. So too, Roe and Casey fit neatly into a long line of decisions protecting from government intrusion a wealth of private choices about family matters, child rearing, intimate relationships, and procreation. Those cases safeguard particular choices about whom to marry, whom to have sex with, what family members to live with, how to raise children, and crucially, whether and when to have children. In varied cases, the court explained that those choices, the most intimate and personal a person can make, reflect fundamental aspects of personal identity. They define the very attributes of personhood, and they inevitably shape the nature and future course of a person's life, and often the lives of those closest to her. So, the court held those choices belong to the individual and not the government. That is the essence of what liberty requires. And liberty may require it. This court has repeatedly said, even when those living in 1868 would not have recognized the claim, because they would not have the person making it as a full-fledged member of the community.
Without seeing the person.
Because they would not have seen the person making it as a full-fledged member of the community. Throughout our history, the sphere of protected liberty has expanded, bringing in individuals formerly excluded. In that way, the constitutional values of liberty and equality go hand in hand. They do not inhabit the hermetically sealed containers the majority portrays. Compare Obergefell. That's the citation. Weird. Wait.
So this is different than CF.
Yeah.
Compare is where the comparison is telling, right? So Obergefell, showing that Obergefell's reasoning is different than what the majority's is.
Okay. So before Roe and Casey, the court expanded in successive cases those who could claim the right to marry through their relationships would have been outside the law's protection in the mid-19th century. And then they cite some cases about interracial couples, prisoners, and offering constitutional protection to untraditional family units. And after Roe and Casey, of course, the court continued in that vein, with a critical stop to hold that the 14th Amendment protected same-sex intimacy. The court resolved that the amendment also conferred on same-sex couples the right to marry in Lawrence and Obergefell. In considering that question, the court held history and tradition, especially as reflected in the course of our precedent, guide and discipline the inquiry. But the sentiments of 1868 alone do not and cannot rule the present. Casey similarly recognized the need to extend the constitutional sphere of liberty to a previously excluded group. The court then understood, as the majority today does not, that the men who ratified the 14th Amendment and wrote the state laws of the time did not view women as full and equal citizens. A woman then, Casey wrote, had no legal existence separate from her husband. Women were seen only as the center of the home and family life, without full and independent legal status under the Constitution. But that could not be true any longer. The state could not now insist on the historically dominant vision of the woman's role. And equal citizenship, Casey realized, was inescapably connected to reproductive rights. The ability of women to participate equally in the life of the nation in all its economic, social, political, and legal aspects has been facilitated by their ability to control their reproductive lives. Without the ability to decide whether and when to have children, women could not, in the way men took for granted, determine how they would live their lives and how they would contribute to the society around them. For much that reason, Casey made clear that the precedents Roe most closely tracked were those involving contraception. Over the course of 3 cases, the court had held that a right to use and gain access to contraception was part of the 14th Amendment's guarantee of liberty. And then they reference Griswold, Einstadt, and Carey v. Population Services International.
Those are all the contraception cases. So Griswold is the one with married couples. Eisenstadt extends that to unmarried couples, and Carey, I think, is the marketing one that we referenced. So those are all the contraception cases.
Gotcha.
And again, they're making clear on the merits of Roe that it's falling in line with these lines of cases that recognize certain decisions as fundamentally individual. And so, yeah, that's why they're setting them.
Gotcha. That clause, we explain, necessarily conferred a right to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. Casey saw...
That's the phrase I use, by the way. Whenever people are like, what is this right? I cite Eisenstadt as the decisional right about whether to bear or beget a child. I think that's one of the best ways to look about it, because you have the contraception cases, you have the sterilization cases, and those, broadly speaking, they speak to the same right. The state might have a bigger interest in abortion, in banning abortion, right? The state might have a bit better interest in banning abortion, but in terms of the right, before you get to the state balancing part, it makes sense, right? It's all about whether or not you have a right to decide whether you're going to have a child or not. That's true of sterilization, that's true of contraception, and that's true of abortion. Yes, in abortion, you can say that there's some factual distinction, especially later on in abortion, but I think that speaks to the state's interest in protecting that potential life, as opposed to whether or not a right even exists in the first place to be free in your decision to decide whether to bear or beget a child. Does that make sense?
Yeah.
Okay.
And we left off at that clause, right?
Yeah.
That clause, we explain, necessarily conferred a right to be free from unwarranted governmental intrusions. No, we did read that.
I'm sorry. I thought you meant did we end there?
Oh, no.
In that line, but yes, Casey saw Roe.
Yeah. Casey saw Roe as of a piece, In critical respects, the abortion decision is of the same character. What are they saying there?
So Casey sees Roe as a continuation of the contraception cases. And the sterilization cases. In critical respects, the abortion decision is of the same character.
Okay, now I get it. Reasonable people, the court noted, could also oppose contraception, and indeed, they could believe that some forms of contraception similarly implicate a concern with potential life. Yet the views of others could not automatically prevail against a woman's right to control her own body and make her own choice about whether to bear and probably to raise a child. This is one line to just succinctly put, like, the whole, just because you believe this thing and you can get enough people to vote for it doesn't mean that you necessarily should be able to do, like, in the times where we were anti-woman suffrage or anti any of these rights, we don't want people to have the ability to just vote it out. Anyhow.
Yes, but I accuse the majority of this. I have to be equal with the dissent. This is me being equal. Would we ever say this of your right to, like, kill your own child at 3 years old? Never.
No.
And we would never say that just because everyone else thinks it's killing a life, you don't get to do it. We'd never say that. And so each of these decisions in their own way, whether that's the dissent or the majority, it affects everyone equally. Is making by even though they're not saying it, the implication of their statements and what we all know about people and what they would say if you were to be like, you have a right to kill your 3-year-old, we know that there are some implicit moral decisions being made here on the merits of the moral question of abortion, and that Breyer, Sotomayor, and Kagan would not be caught dead saying this unless they thought they took the view that it's not equal to a 3-year-old. If they said it was equal to the 3-year-old or a 1-year-old or even a newborn infant, do you think Breyer, Sotomayor, and Kagan would be saying this? No. And so even in the dissent, in the same way as the majority, the moral question of abortion and what is a human life is a specter that hangs over these opinions.
Yes. Although in my brain, in my crazy hypothetical debate bro brain, like I look at the line, whether to bear and probably to raise a child. The raising of the child thing, we already have off the table. You can go put your child up for adoption, whatever. And if medical technology was only at a point where the Roe standard made sense of viability, then you wouldn't have to bear the child either. The abortion procedure could involve moving it into something that allows it to, like, continue to live and whatever. And I think that, like, ideally in the future, that's where we get to, where, like, states.
That's super. That gets you into, like, the merits of what is a human life and, like, why. Right. If it's a human life at conception, there are a bunch of fertilized frozen eggs that people will make for in vitro fertilization. Are we, like, concerned when we have to destroy them, or are we, like, concerned that we should, like, find a surrogate to put every single frozen fertilized egg in? No. The answer is no.
But
should we be concerned with that?
That would still be answered here. That you can't force people to bear or raise a child. Right? Like that's why in my mind, if we were only like 1,000 years in the future or something, this would be way easier to determine. Like, okay, well, if you're a crazy fucking conservative state that wants to have these laws, then invest in your healthcare system and have a way to, like, artificially raise all these kids. Then if that really matters to you, then we'll see if you care about it as much as you care about other things in the healthcare field. And if you're willing to make the investment to make that happen, but you can't force a woman to fucking bear or raise a child. You shouldn't be able to force anybody to do that. And furthermore, I think that this should also apply to men. Men shouldn't be on the hook financially or otherwise to raise a child that they don't want to raise. Like, I think that goes across the sexes and the genders and whatever.
Interesting.
Yeah. But that's like my crazy take.
No, but that take is, like, it is consistent, right? How can you be citing all of these interests of women? By the way, we're even being a little cis-normative here by assuming that only women can get pregnant, right?
Okay.
But let's just say for the uterus-bearing individuals, if we are making all these claims and saying that it's so costly to bring a child in the world, and why should a woman have to bear that? Why should a uterus-having individual be forced to bear that cost? Why should a man be forced to bear that cost?
Yeah. And
Or sorry, penis-having individual.
there you go. Yeah. Or just men, because like,
Or
you
men.
know, even if you identify as a man and
Sure.
you know, whatever, you shouldn't have to. Also, thank you to Hot Bio Lava. Interesting to see you in a non-drama stream supporting the channel through donations and stuff. I do appreciate that. I know you're more into like, you know, 11-hour Mr. Girl reviews. So whatever. Yeah. Thank you for that. Let's see here. So I think we left off at when an unplanned pregnancy. So when an unplanned pregnancy is involved, because either contraception or abortion is outlawed, the liberty of the woman is at stake in a sense unique to the human condition. No state could undertake to resolve the moral question raised in such a definitive way as to deprive a woman of all choice. Faced with all these connections between Roe and Casey and judicial decisions recognizing other constitutional rights, the majority tells everyone not to worry. It can, so it says, neatly extract the right to choose from the constitutional edifice without affecting any associated rights. Think of someone telling you that the Jenga tower simply will not collapse. Weird addition, but okay. Today's decision, the majority first says, does not undermine the decisions cited by Roe and Casey, the ones involving marriage, procreation, contraception, and family relations in any way. Note that this first assurance does not extend to rights recognized after Roe and Casey and partly based on them, in particular, rights to same-sex intimacy and marriage. Jesus, it was serious shade there. Okay. On its later tries, though, the majority includes those too. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. That right is unique, the majority asserts, because abortion terminates life or potential life. So the majority depicts today's decision as a restricted railroad ticket, good for this day and train only. Where is that coming from? Oh, Roberts and the dissenting. Interesting. In a case from a gazillion years ago. Wait, what? What? Why is the quote being used like this from a case from 1944? Wait, do you understand what this case is or why it's being used like this? Please read footnote 6. Oh, we may have lost you, Pisco, unless you're not talking.
Oh, can you hear me? I'm sorry. Oh,
I
I was
can
muted. I'm sorry. I'm muted because I had to type something. My apologies. So I don't know this Smith versus Allwright case. It's a different Justice Roberts, not Chief Justice Roberts. He wasn't a chief Supreme Court justice in 1944. So basically, what I think we're getting at here is that this opinion is unique to abortion.
Mm-hmm.
And it doesn't apply to anything else just because the court says it doesn't apply to anything else.
Gotcha.
And that is fucked, right?
Yeah.
You want to, if you have a rationale, that rationale should apply elsewhere. That's why what Thomas wants so logically follows. It so logically follows that if overturning Roe v. Wade in the manner that the majority opinion overturned it. You could overturn it on different grounds, right? You could say that abortion is very much in line with these other rights, but we just think that the state's interest in potential life is so high that at any point in time you can have an abortion. That would be overturning Roe v. Wade, but recognizing that the approach, at least in finding those fundamental rights, is not just this narrow historical approach, right? But the way they did it, the rationale, at least from my perspective, Clarence Thomas just wins on that logic.
Sure.
Now you can say this opinion doesn't cast doubt, but you're just saying it. You're just saying it because you have the votes, and it just is the way it is because it is the way it is because you have the votes. But if you're following the formal legal logic, I think Clarence Thomas wins.
And somebody pointed us to look at footnote 6, which I agree with, but I will need your help in interpreting. So the lines before it is, note that this first assurance does not extend to rights recognized after Roe and Casey and partly based on them. In particular, rights of same-sex intimacy and marriage. And then it says, see supra at 23. And then if you could help us to read and interpret this footnote.
Yeah, so supra, just so you know, supra is before. So it's basically saying we made this point on page 23 of our dissent. And so what they're saying is like, don't trust them, especially don't trust them on the same-sex stuff. And now we're going to go to the footnote to find out why. And note too that the author, thanks for the gift subs.
Thank you. Do appreciate that. That's very cool of you.
And note too that the author of the majority opinion recently joined a statement written by another member of the majority lamenting that Obergefell deprived states of the ability to resolve the question of same-sex marriage through legislation. So what he's saying is, Alito, you just signed on a statement in 2020 along with Clarence Thomas, essentially saying you want to overturn Obergefell. And you sit here with a straight face and say it's not under risk? The only reason you say that is to get a majority of the court.
Yeah, and then it continues.
And those two justices hardly seemed content to let the matter rest. The court, they said, had created a problem that only it can fix.
And then it points to
this opinion, Davis.
Yeah, and then it continues. That might sound familiar. CF Ante at 44 lamenting that Roe short-circuited the democratic process. So tying a thematical line between those statements. And those two justices.
I missed that part,
yeah, like interesting. So that tie-in is interesting to me.
It's the same rationale, Bookie. It's the same. So when I say like this absolutely undermines other rights, like it just does. It's the same logic. It's the same shit. It's the same talking points. And you can either be honest about that and say the only thing defending those other rights is just because the members of the majority want to defend those rights. Or you can be a real one, and a real one would say like, this absolutely does undermine it. And the only reason it wouldn't result in the overturning of those cases is because of either one, stare decisis, which this court shows like think about the stare decisis analysis. The stare decisis analysis for Roe v. Wade is so much stronger than that for gay marriage cases. The gay marriage and the gay sex cases, those are more recent opinions, right? Those are opinions that don't have as many cases affirming them. Less time has passed for a reliance interest. Although maybe you see the reliance interest is great for like marriages that already exist. But like, I think the stare decisis analysis is like a lot easier and stronger for Roe v. Wade and Casey than it is for these other cases. And so the only thing that would save those other cases is the Supreme Court just applying stare decisis in those cases on an arguably weaker argument, or some stupid attempt to distinguish.
Although, and I disagree with the dissent a little bit here. Like, I think that they have a way clearer. Like, I think you and I talked about a hypothetical world where Roe isn't passed, and that perhaps the states, in a similar way with Obergefell, move so close to everybody approving gay marriage that it makes it easier for the Supreme Court to rule on that decision and keep that decision around. Whereas with abortion, we weren't in the same place. In 2015, a majority of the states, I think it was like 30 some states, had laws on the books to allow that. Yeah. Whereas
maybe civil unions, I think the minority of states had. You could be right. I don't know. You could be right. I actually don't know, so I shouldn't say that.
Yeah. Whereas like the law that they were stating to try and the law that the Sixth Circuit Court used to throw out Obergefell or deny their appeal or whatever was based on a way earlier case where they said that like in Minnesota that they weren't allowing for same-sex marriage or like across state lines, and even Minnesota had overturned that before 2015. So that was part of the court's reasoning is like, dude, even the Minnesota statute that the Sixth Circuit Court is using here ended up being overturned by the way that the law headed in. The direction they headed in was the exact opposite. So it seems very clear that like this ruling is incorrect. And that's what I'm remembering from that case in particular. And there was some citation about 30 some states, either they have laws in the books or they're going to have laws in the books that would have allowed that.
Yeah, there's an interesting question whether the tail wags the dog and the dog wags the tail. Is the Supreme Court making people more open to gay marriage, or is people being more open to gay marriage making the Supreme Court mandate that it be legal?
And I think it's like undeniably stronger if the latter is happening, if the Supreme Court is making a decision in which the majority of the states are going that direction, which is what makes the majority's opinion here seem to be strong from my perspective, from like a states' rights standpoint. Because if like the majority of the states are petitioning the court to overrule Roe and Casey, then there's a bit of a problem going on there, given public opinion seems to be going all one way. But if it's going the opposite direction, that's way stronger for the court, I feel like.
Yeah. I agree. I think that the court in Roe v. Wade was wading into an area where public sentiment was probably not as sympathetic as the gay marriage case. I'll say that much. I'll say that much at least,
Yeah. And so in that way, this comparison, I feel like, is a little bit iffy, because it's like, well, no, these are two very different, these are two very different situations. And it could well be argued that you short-circuited the democratic process in the case of Roe, but not in the case of Obergefell. Even if these sound similar in their reasoning, they're for very different scenarios. But anyway, that's my polygamist hat.
Yeah. Oh. All right, sounds good. Let's keep going.
Okay. So I think we go to the first problem with the majority's account comes from Justice Thomas's concurrence. Oh boy, here we go. Which makes clear he is not with the program. Interesting that they write like that. What the hell? In saying that nothing in today's opinion casts doubt on non-abortion precedents, Justice Thomas explains he means only that they are not at issue in this very case. And then the quote is, "This case does not present the opportunity to reject those precedents, but he lets us know what he wants to do when they are. Quote, in future cases, he says, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. And when we reconsider them, then we have a duty to overrule these demonstrably erroneous decisions. So at least one justice is planning to use the ticket of today's decision again and again and again. Even placing the concurrence to the side, the assurance in today's opinion still does not work. Or at least that is so if the majority is serious about its sole reason for overturning Roe and Casey, the legal status of abortion in the 19th century. Except in the places quoted above, the state interest in protecting fetal life plays no part in the majority's analysis. To the contrary, the majority takes pride in not expressing a view about the status of the fetus. The majority's departure from Roe and Casey rests instead, and only, on whether a woman's decision to end a pregnancy involves any 14th Amendment liberty interest, against which Roe and Casey balance the state interest in preserving fetal life. According to the majority, no liberty interest is present because, and only because, the law offered no protection to the woman's choice in the 19th century. But here is the rub. The law also did not then, and would not for ages, protect a wealth of other things. It did not protect the rights recognized in Lawrence and Obergefell to same-sex intimacy and marriage. It did not protect the right recognized in Loving to marry across racial lines. It did not protect the right recognized in Griswold to contraceptive use. For that matter, it did not protect the right recognized in Skinner v. Oklahoma not to be sterilized without consent. So if the majority is right in its legal analysis, all those decisions were wrong, and all those matters properly belong to the states too, whatever the particular state interest involved. And if that is true, it is impossible to understand as a matter of logic and principle, which is what you were saying, how the majority can say that its opinion today does not threaten, does not even undermine any number of other constitutional rights. Nor does it even help to take the majority at its word. Assume the majority is sincere in saying, for whatever reason, that it will go so far and no further. Scout's honor. What the fuck why are we writing like this?
It's a dissent. I think it's a very snarky dissent.
Yeah, they're so casual.
What they're saying is like Scout's honor, like, because that's the only thing we have to go on, pretty much.
I know why they're saying it. It's just so weird to read. Scout's honor. Still, the future significance.
Wait. Really big, important footnote 8. Right? Because one way you could try to distinguish if you're the majority is you could say stare decisis plays out differently. And here we go. The majority very briefly, just said the idea that some stare decisis factors might play out differently with respect to these other constitutional rights, but the majority gives no hint as to why. And the majority's mistreatment of stare decisis in this case provides little reason to think the doctrine would stand as a barrier to the majority's redoing any other decision it considers egregiously wrong. And so that's why they're saying, like, you say stare decisis might come out differently, but like you don't give us a reason why it would come out differently. And there's nothing that we should trust that you respect stare decisis enough to like treat it well in these other cases.
And footnote 7, which is for the sentence, the majority's departure from Roe and Casey rests instead and only on whether a woman's decision to end a pregnancy involves any 14th Amendment liberty interests, against which Roe and Casey balance the state interest in preserving fetal life. They say, indulge a few more words about this point. The majority had a choice of 2 different ways to overrule Roe and Casey. It could claim that those cases underrated the state's interest in fetal life. Or it could claim that they overrated a woman's constitutional liberty interest in choosing an abortion, or both. The majority here rejects the first path, and we can see why. Taking that route would have prevented the majority from claiming that it means only to leave this issue to the democratic process, that it does not have a dog in the fight. And indeed, doing so might have suggested a revolutionary proposition, that the fetus is itself a constitutionally protected person, such that an abortion ban is constitutionally mandated. The majority therefore chooses a second path, arguing that the 14th Amendment does not conceive of the abortion decision as implicating liberty, because the law in the 19th century gave that choice no protection. The trouble is that the chosen path, which is, again, the solitary rationale for the court's decision, provides no way to distinguish between the right to choose an abortion and a range of other rights, including contraception. So casting shade on the contraception thing there.
That just like, there is no way to distinguish using the logic of the opinion. In order to distinguish, you have to like just take it at Scout's honor, which is where I think we left off.
Yeah. Still, the future significance of today's opinion will be decided in the future, and law often has a way of evolving without regard to original intentions, a way of actually following where logic leads rather than tolerating hard-to-explain lines. Rights can expand in that way. Dissenting in Lawrence, Justice Scalia explained why he took no comfort in the court's statement that a decision recognizing the right to same-sex intimacy did not involve same-sex marriage. That could be true, he wrote, only if one entertains the belief that principle and logic have nothing to do with the decisions of this court. Jesus.
Yeah. No, but that's so true. Like Scalia's pretty much what's the right term? He's freaking out in Lawrence. That's the gay sex case, saying it's going to lead to gay marriage being constitutional. and the majority in Lawrence is like, we don't have any decision on gay marriage today. But Scalia's like, but logically it follows if you follow this line, and he was right. That's where it led.
Score one for the dissent as a matter of prophecy. Jesus. And logic and principle are not one-way ratchets. Rights can contract in the same way and for the same reason, because whatever today's majority might say, one thing really does lead to another. We fervently hope that does not happen because of today's decision. We hope that we will not join Justice Scalia in the Book of Prophets, but we cannot understand how anyone can be confident that today's opinion will be the last of its kind. Consider as our last word on this issue, contraception. The Constitution, of course, does not mention that word, and there is no historical right to contraception of the kind the majority insists on. To the contrary, the American legal landscape in the decades after the Civil War was littered with bans on the sale of contraceptive devices. So again, there seem to be two choices. If the majority is serious about its historical approach, then Griswold and its progeny are in the line of fire too. Or if it is not serious, then what is the basis of today's decision? If we had to guess, we suspect the prospects of this court approving bans on contraception are low. But once again, the future significance of today's opinion will be decided in the future. At the least, today's opinion will fuel the fight to get contraception and any other issues with a moral dimension out of the 14th Amendment and into state legislatures. Anyway, today's decision, taken on its own, is catastrophic enough. As a matter of constitutional method, the majority's commitment to replicate in 2022 every view about the meaning of liberty held in 1868 has precious little to recommend it. Our law in this constitutional sphere, as in most, has for decades upon decades proceeded differently. It has considered fundamental constitutional principles, the whole course of the nation's history and traditions, and the step-by-step evolution of the court's precedents. It is disciplined, but not static. It relies on accumulated judgments, not just the sentiments of one long-ago generation of men who themselves believed and drafted the Constitution to reflect that the world progresses. And by doing so, it includes those excluded from that olden conversation rather than perpetuating its bounds. As a matter of constitutional substance, the majority's opinion has all the flaws its method would suggest. Because laws in 1868 deprive women of any control over their bodies, the majority approves states doing so today. Because those laws prevented women from charting the course of their own lives, the majority says states can do the same again. Because in 1868, the government could tell a pregnant woman, even in the first days of her pregnancy, that she could do nothing but bear a child, it can once more impose that command. Today's decision strips women of agency over what even the majority agrees is a contested and contestable moral issue. It forces her to carry out the state's will, and whatever the circumstances and whatever the harm it will wreak on her and her family. In the 14th Amendment's terms, it takes away her liberty. Even before we get to stare decisis, we dissent. I love this repetition of the dissent at the end of all the sections here. Section 2. By overruling Roe, Casey, and more than 20 cases reaffirming or applying the constitutional right to abortion, the majority abandons stare decisis, a principle central to the rule of law. Stare decisis means to stand by things decided. Blackstone called it the established rule to abide by former precedents. Stare decisis promotes the even-handed, predictable, and consistent development of legal principles. It maintains a stability that allows people to order their lives under the law. Stare decisis also contributes to the integrity of our constitutional system of government by ensuring that decisions are founded in the law rather than in the proclivities of individuals. It avoids an arbitrary discretion in the courts, as Hamilton wrote in The Federalist. And as Blackstone said before him, it keeps the scale of justice even and steady, and not liable to waver with every new judge's opinion. The glory of our legal system is that it gives preference to precedent rather than juris. That is why, the story goes, Chief Justice John Marshall donned a plain black robe when he swore the oath of office. That act personified an American tradition. Judges' personal preferences do not make law. Rather, the law speaks through them. That means the court may not overrule a decision, even a constitutional one, without a special justification. Stare decisis is, of course, not an inexorable command. It is sometimes appropriate to overrule an earlier decision. But the court must have a good reason to do so, over and above the belief that the precedent was wrongly decided. It is not alone sufficient that we would decide a case differently now than we did then. The majority today lists some 30 of our cases as overruling precedent and argues they support overruling Roe and Casey, but none does, as further described below and in the appendix. In some, the court only partially modified or clarified a precedent, and in the rest, the court relied on one or more of the traditional stare decisis factors in reaching its conclusion. The court found, for example, 1, a change in legal doctrine that undermined or made it obsolete the earlier decision, 2, a factual change that had the same effect, or 3, an absence of reliance because the earlier decision was less than a decade old. The majority is wrong when it says that we insist on a test of changed law or fact alone, although that is present in most of the cases. None of those factors apply here. Nothing, and in particular, no significant legal or factual change supports overturning a half-century of settled law, giving women control over their reproductive lives. First, for all the reasons we have given, Roe and Casey were correct in holding that a state could not resolve the debate about abortion in such a definitive way that a woman lacks all choice in the matter. The court protected women's liberty and women's equality in a way comporting with our 14th Amendment precedents. Contrary to the majority's view, the legal status of abortion in the 19th century does not weaken those decisions, and the majority's repeated refrain about usurping state legislatures' power to address a publicly contested question does not help it on the key issue here. To repeat, the point of a right is to shield individuals and decisions from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. However divisive, a right is not at the people's mercy. In any event, whether or not we agree with a prior precedent is the beginning, not the end, of our analysis, and the remaining principles of stare decisis weigh heavily against overruling. Casey itself applied those principles in one of this court's most important precedents about precedent. After assessing the traditional stare decisis factors, Casey reached the only conclusion possible. The stare decisis operates powerfully here. It still does. The standards Roe and Casey set out are perfectly workable. No changes in either law or fact have eroded the two decisions, and tens of millions of American women who have relied and continue to rely on the right to choose. So under traditional stare decisis principles, the majority has no special justification for the harm it causes. And indeed, the majority comes close to conceding that point. The majority barely mentions any legal or factual changes that have occurred since Roe and Casey. It suggests that the two decisions are hard for courts to implement but cannot prove its case. In the end, the majority says, all it must say to override stare decisis is one thing, that it believes Roe and Casey egregiously wrong. That rule could equally spell the end of any precedent with which a bare majority of the present court disagrees. So, how does that approach prevent the scale of justice from wavering with every new judge's opinion? It does not. It makes radical change too easy and too fast, based on nothing more than the new views of new judges. The majority has overruled Roe and Casey for one and only one reason, because it has always despised them, and now it has the votes to discard them. The majority thereby substitutes a rule by judges for the rule of law. Damn. Section A. Contrary to the majority's view, there is nothing unworkable about Casey's undue burden standard. Its primary focus on whether a state has placed a substantial obstacle on a woman seeking an abortion is a sort of inquiry familiar to judges across a variety of contexts. And it has given rise to no more conflict in application than many other standards this court and others unhesitatingly apply every day. General standards, like the undue burden standard, are ubiquitous in the law, and particularly in constitutional adjudication. When called on to give effect to the Constitution's broad principles, this court often crafts flexible standards that can be applied case by case to a myriad of unforeseeable circumstances. C. Dickerson, quote, "No court laying down a general rule can possibly foresee the various circumstances in which it must apply." So, for example, the court asks about undue or substantial burdens on speech, on voting, and on interstate commerce. See Arizona Free Enterprise Club's Freedom Club PAC v. Bennett, Burdick v. Takushi, Pike v. Bruce Church Incorporated, etc. The Casey undue burden standard is the same. It also resembles general standards that courts work with daily in other legal spheres, like the rule of reason in antitrust law or the arbitrary and capricious standard for agency decision
Can we talk
making.
about this for real quick?
Sure.
So basically what they said was one of the factors that started assessing is workability. Workability means like how can judges apply this stuff? Undue burden standard relates largely to not to bans of abortions, but to like regulations of abortions. And people have said like, well, how do I know what's a due burden, what's an undue burden, and it's hard to apply or whatever. That's like what judges are supposed to do. Like there's this whole what does it mean for something to be reasonable, right? Like who the hell knows? What does reasonability mean? What does arbitrary and capricious mean for purposes of the Administrative Procedures Act? That's what they mentioned. That's like a very important provision of administrative law. What is like half of these standards? Think about like compelling purpose and tiers of scrutiny and rational basis. Like these things don't decide themselves. We need judges to use their reason to apply these standards. And so like to be like, oh, we have no reason to like, we have no way to apply this standard. Like, do you have a way to apply reasonability? Do you have a way to apply any of these other kind of nebulous things that we decide that judges are empowered to rule upon? And if you do have the power to do that stuff, why don't you have the power to figure out what an undue burden is over time through a thing called precedent?
I'll keep it a buck 50 with you, Pisco. Yeah. Like, my opinions have been like moving and changing over the course of reading all these opinions. Like when I heard about the undue burden thing or about the viability thing, I see those as hazy and difficult and like general. But then when we bring up that like, well, tons of laws are like this, and the whole point is to give flexibility for judges to consider things on a case-by-case basis, like, oh, I didn't even really think about that because it's not really presented to me in the same breath as like the criticism. And so like, you know, there's a lot of that going on, which can also lead me to be a bit more sympathetic to people who like, if all they consume are particular quotes from like the concurring opinions here or the majority opinion, then like I can understand why they have the opinions they have if they aren't considering the other side of things here.
Well, they don't read that bookie. And it's so like, really, there are some principles of law that are like, let's take the arbitrary and capricious standard. What does that mean, right? What does it mean for something to be arbitrary and capricious such that the government is not allowed to like pass a regulation that's like that? Who the fuck knows, right? like I think it has something to do with not having reason for your judgment, but like what's a good enough reason? What's a good enough like investigation? Let's say that you want to get rid of the rules for net neutrality, right? What's a good enough investigation that you have to make in order to determine that like the pros and costs of the analysis? Like that's we have this notion that the arbitrary and capricious standards requires governments to like do a little research or do a little fact finding or do something. What is that thing? Like who the hell knows? Judges decide that, courts decide that, you have precedent. It's based on like logic and reason, and you do your best. Like at some end, there's some grounding that you're gonna have to have with like some, I don't know, some bedrock of like reasonability that you're gonna have to apply in some cases. And the undue burden standard, yeah, you could say you want to say it's unworkable. Well, Casey gave you some examples of things that it considered to be undue burdens, you know, and you work by analogy. It's an undue burden to have a spousal notification. It's not an undue burden to have a 24-hour notification. And you work from there. You work from analogy. Like I just don't understand the big deal about that. Sorry, my rant is over. I've been rambling.
And they don't cite examples, which is a good point made here. Like you're not pointing us towards cases where the standard was proved to be unworkable. Like you don't have examples of a ton of cases where judges are confused and they don't know how to apply the laws.
Oh, shit. Yeah, dude, there's not even like major circuit splits on this issue. A circuit split is like when one federal court says one thing and then like another circuit says something else, so you have like different rules in the country. There's not even like major like circuit splits. There are major fucking circuit splits on like issues of copyright that have been around for like literally decades, like decades and decades, and we have court disagreements on what it means to like copy something. Like what is it like? Basic fundamental principles of fucking copyright law to this day have like circuit splits on them. So I just don't understand, and I think the dissent gets into the circuit split stuff. So keep reading.
Okay, but yeah, like if we don't have the examples, then you're not making your case. You're talking about hypotheticals. Yeah. Like, anywho. So applying general standards to particular cases is, in many contexts, just what it means to do law.
Oh, look, there you said it. Yeah, absolutely. Yeah, that is it.
And the undue burden standard has given rise to no unusual difficulties. Of course, it has provoked some disagreement among judges. Casey knew it would. That much is to be expected in the application of any legal standard which must accommodate life's complexity, which is to say that much is to be expected in the application of any legal standard. But the majority vastly overstates the divisions among judges applying the standard. We count essentially two. The Chief Justice disagreed with other justices in the June medical majority about whether Casey called for weighing the benefits of an abortion regulation against its burdens. We agreed that the June medical difference is a difference, but not one that would actually make a difference in the result of most cases. It did not in June medical, and not one incapable of resolution were it ever to matter. As for lower courts, there is now a 1-year-old, 1-to-1 circuit split about how the undue burden standard applies to state laws that ban abortions for certain reasons, like fetal abnormality.
Oh, it's only one circuit split.
Yeah, that is about it, as far as we can see, and that is not much. The footnote says some lower courts then differed over which opinion in June medical was controlling, but that is a dispute not about the undue burden standard, but about the Marx rule, which tells courts how to determine the precedential effects of a divided decision.
So the circuit split on how to interpret a Supreme Court decision, not a circuit split on the application of the undue burden standard. That's what they're saying.
Yeah. And then in footnote 11, they say the rest of the majority's supposed splits are, shall we say, unimpressive. The majority says that lower courts have split over how to apply the undue burden standard to parental notification laws, but that is not so. The state law upheld an exemption for minors demonstrating adequate maturity, whereas the ones struck down did not. The ones struck down did not. And we have a bunch of citations. The majority says there is a split about bans on certain types of abortion procedures, but the one court to have separated itself on that issue did so based on a set of factual findings significantly different from those in other cases. Finally, the majority says there is a split about whether an increase in travel time to reach a clinic is an undue burden. But the cases to which the majority refers predate this court's decision in Whole Woman's Health v. Hellerstedt, which was in 2016, which clarified how to apply the undue burden standard to that context. Oh. So even in that case, they ended up coming up with how to deal with it. So okay.
Yeah, like half these things have ended in the Supreme Court. Like we have a couple abortion cases, I feel like every few years, and that's just what you do, bro. Like, there's how many First Amendment cases are there? There are so many First Amendment cases. How many like cases about IP law? I actually don't know. Like, probably a lot. How many cases about like let me think of another good example. Someone think of something good. The Second Amendment, we don't have that many. But like, we're gonna probably have a bunch of Second Amendment cases coming soon. Court doesn't seem too like worried about that coming in the future, about like people disagreeing on what the historical regulations were, or people disagreeing on application of that in the Second Amendment context. I just think it's like, it just feels like concern trolling. It really does.
Yeah.
All right, my polemicist hat is full out. I'm absolutely in agreement with the dissent here.
It's okay. Someone asked me to summarize the last 2 hours. So what I'll say is, with Roberts, he basically only wanted to dump the viability standard, and he thought that a compromise for the court could have been to just say, hey, this viability standard is no good. The undue burden standard is probably no good, but women should still have the right to an abortion. And that's the only part that we really need to rework. We don't have to consider more stuff because it's not in the case before us. We don't have to overrule this entire decision in Roe and Casey and all the precedent that goes with it. The dissent thinks that the majority are lying, or actually believe that we should limit rights to what the people who wrote them thought, even if those people that wrote them had thought something, for instance, like women shouldn't have rights because women are not able to vote, and they're not able to do a gazillion other things that men should do. And they probably didn't think things like the 14th Amendment, or even the things that were framed in the Constitution initially, should even apply to women. And they think that like we have an evolving view of rights based on these texts, and we interpret them over the course of legal evolution, cultural evolution, political evolution. And that's the whole point of this document. It's meant to be a living document that we as justices interpret based on where society is going and where it's come from. And we're not meant to just limit our view of what those rights and who they should apply to the people that actually wrote the documents. Because if we did that, we'd overrule everything from, interracial marriage to, contraceptives and women's rights more generally. So that's kind of the TLDR. Anywho, jumping back here, which I believe...
A good TLDR.
Yeah. And that is not much. This court mostly does not even grant certiorari on 1-year-old 1-to-1 circuit splits, because we know that a bit of disagreement is an inevitable part of our legal system. To borrow an old saying that might apply here, not one or even a couple of swallows can make the majority summer. What does that mean?
Probably that it's like okay to have a couple circuit splits.
Okay.
It's probably even like a little healthy, right? It's probably like a little healthy to have some disagreement in the lower courts, and you get the reasoned opinion, and then eventually gets to the Supreme Court. Like, but I don't know exactly where that comes from.
Okay, Dr. Concept says swallows are a bird that arrives in summer. So, if you just have a couple that come at once, that doesn't mean that the summer has come. Maybe something like that. Okay, so you can't characterize everything based on a couple of things that don't fit.
Yeah.
Okay. Anyone, that's some old people shit, dude. Anyone concerned about workability should consider the majority substitute standard. The majority says a law regulating or banning abortion must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. And the majority lists interests like respect for and preservation of prenatal life, protection of maternal health, elimination of certain medical procedures, mitigation of fetal pain, and others. This court will surely face critical decisions about how that test applies. Must a state allow abortions when necessary to protect a woman's life and health? And if so, exactly when? How much risk to a woman's life can a state force her to incur before the 14th Amendment's protection of life kicks in? Suppose a patient with pulmonary hypertension has a 30 to 50% risk of dying with ongoing pregnancy. Is that enough? And short of death, how much illness or injury can the state require her to accept consistent with the amendment's protection of liberty and equality? Further, the court may face questions about the application of abortion regulations to medical care most people view as quite different from abortion. What about the morning after pill? IUDs? in vitro fertilization? And how about the use of dilation and evacuation or medication for miscarriage management? Finally, the majority's ruling today invites a host of questions about interstate conflicts. Then they have a long list here. Can a state bar women from traveling to another state to obtain an abortion? Can a state prohibit advertising out-of-state abortions or helping women get to out-of-state providers? Can a state interfere with the mailing of drugs used for medication abortions? The Constitution protects travel and speech and interstate commerce, so today's ruling will give rise to a host of new constitutional questions. Far from removing the court from the abortion issue, the majority puts the court at the center of the coming interjurisdictional abortion wars. In short, the majority does not save judges from unwieldy tests or extricate them from the sphere of controversy. To the contrary, it discards a known, workable, and predictable standard in favor of something novel and probably far more complicated. It forces the court to wade further into hotly contested issues, including moral and philosophical ones that the majority criticizes Roe and Casey for addressing.
Okay, Bookie.
Yeah.
I have to go. I want to finish this opinion, but damn, we got 30 pages left.
Oh, fuck. That's a long one.
Yeah. Is there any... So I know exactly where we are. We're at part 1 of the stare decisis analysis, and there's a couple more factors to consider. This first one was workability. Basically, the court is saying... Sorry, the dissent is saying... you're not any more workable than us. Like, you have a ton of questions that are kind of come up as a result of this ruling, and that's absolutely true. And we had this standard for a long time. We knew it, we were working with it, and now you just upset it into something that's like into unknown territory. And so that's kind of where we're at. I would love to continue, but I don't have the time anymore today. Is there any way we could, I know, extend it to one more day of analysis?
You know, with what we're doing, it takes as long as it takes, you know, to do a good job. So
amazing. Well, thank you so much for having me, bro. I appreciate you.
Yeah.
I think this is really good what we're doing. And I'm glad that you're like in real time noticing things that maybe you would change or and even things when you don't agree with the dissent, you pointed out. And so I appreciate your approach here, bro.
Yeah, hopefully in the future, I don't know, maybe more streamers will sign on to it. Maybe we could even get Steven to dedicate an arc to reading this stuff. Like, I feel like he wouldn't be far from taking on such an endeavor, given his approach to debates and stuff. Like,
yeah, I think if you kept him interested, it'd have to be something that he's like already interested in learning about. Mm-hmm. But I think you could get that. I think that could definitely happen.
Yeah.
But yeah, thank you so much for having me. Appreciate the chat as always. Much love to everyone who stuck by. J Caps in the chat. I see you. Hot Bio Lava, Mirror, even Professor. Yeah. Much love to all you guys. I'm out. Happy 4th of July, and thank you, Bookie, most of all.
Yeah, and thank you for coming on and spending your time with me. I do appreciate the help with reading through this. It definitely makes a huge difference in interpreting things.
Of course. All right. See you later.
Bye. Have a good one. Big Fitty. Another Big Fitty from Hot Bio Lava. Let's hear what Hot Bio Lava has to say.
I highly appreciate the time you're taking to read this decision. Here's my support for this kind of stream.
Thank you. And thank you to our sponsor, #ad, #sponsored, Into the AM. In case you guys didn't know, the clothes that you often see me wearing on the stream, these kinds of like graphic tees and stuff, they're all coming from Into the AM. They're somebody who I've worn the clothes of for a long, long time. It makes up like more than half of the shirts in my luggage that I brought with me all over the world. They don't fall apart. The designs don't start peeling off of the fucking shirt. They don't crack like a motherfucker. These are clothes that will last. I highly, highly recommend that if you want to support the channel but don't want to donate to it, that if you need shirts, if you need socks, if you need shorts, if you need, whatever, hoodies, would highly recommend that you check them out. They have some interesting jackets, like a reflective one. So if you're out and about late at night, maybe going for a late night walk, listening to a bookie stream or something like that, you might want that to keep you safe on the side of the road. I know I get a lot of comments on that reflective jacket when I wear it. I can highly recommend their hoodies, which I've made great use of. It's a kind of like polyester cottony blend that's very, very comfy and soft while remaining like really, really thick. It's not that kind of shitty Fruit of the Loom type shit where it's like super thick and over time it gets to be a little bit rough to the touch. They're really, really nice and really, really subtle. They don't come with a gazillion designs on it. So if something like this isn't your speed, then you can get that, and it's a very subtle little logo placed on it. Or if you'd like to make a statement, I mean, these are shirts that I get comments on all the time. It's not often that I get comments on my clothes from a random stranger at the Starbucks or the airport or something like that. But when I wear these shirts, I certainly do. So, you know, if that's appealing to you, that's something to consider as well. And I'm not the only person that they support. They support a bunch of small content creators. As you know, with this stream, it's really hard for me to accept sponsorship deals because a lot of the time I try the product off stream and it falls apart or otherwise does not meet up to my standards for how good something should be before I plug it to you guys and tell you that you should buy it. I take that really, really seriously at this point, maybe not later. You know, I'm not at sell level yet. But, you know, their support of the stream and the support of any future sponsors will help us to continue creating content like this, where I'm able to really ignore the view count and do something that I think is good, partly because I know that we have sponsors to support the content. They have dedicated themselves to 2 months of sponsored content. So if you'd like to let them know that that's definitely something they should continue to do, then use my code, do !into the AM to get a sponsored link, where if you buy anything and use my link to their website, it'll give a kickback to me and let them know that these integrations are working. Alternatively, I think there's code booksmarts or something like that you could use at checkout, but I'd highly recommend that you start from the link. And it's just intotheam.com/booksmarts. Big thanks to Into the AM for sponsoring this content. It means the most, and I really do appreciate that. Like I said before, there are tons and tons of products that I get sent, and I'm like, there's no fucking way that I will promote this to people. But even when I'm not sponsored by them, you often will see me wearing their stuff because I genuinely enjoy it, and it's genuinely stuff that like doesn't fall apart, and I'm happy to have in my luggage because I'm not afraid that it'll rip or tear or have some other huge defect that will cause a problem for me. Beyond that, they have sales on their website all the fucking time. They're constantly doing new seasons of new designs, and every time that they do, they'll give you as much as 50% off other kinds of shirts and stuff that's on the website. So, you know, you get a really good deal on a t-shirt or a hoodie or shorts. If you just go check out their website, there might be something there on sale that you would be interested in. I know that for me, when I need new clothes, especially new t-shirts, I will hit up them and be like, yo, I need some new shit, dude. Let's see if we can get a package deal going. So huge thank you to Into the AM for sponsoring today's stream and all of our streaming content for the next couple of months here. Like I said before, it means the most, and it would be helpful if you guys would buy something from my sponsored link. It lets them know the integrations work, and that's the end of that plug. Thank you to Into the AM. And you can always get that by using !into the AM in the chat, in either one of them, frankly. So there you go. There's that. There's my club. Everything is 20% off right now. Poggers. There you go. Yeah, I guess everything is 20% off. So you're saving a boatload. It's not like they're expensive clothes to begin with. You know, it's not some fancy pants website where you're paying $1 gazillion for a graphic tee. They're the same prices that you would see at like a regular store, like what you might pay at Target or what you might pay at like, I'm really showing my poverty card here, like Walmart and stuff, right? Like you're getting affordable clothes. So it's not like it's a huge ask or whatever. Or I'm telling you to buy some luxury product that so few of you would be able to afford. It's something that even me, a homeless traveling hermit, is also able to afford. So I would highly recommend you check them out. That being said, another thank you to the people who have financially supported the stream today. We had Hot Bio Lava and Stixon with their, their subs, and thank you also to CMG, Jacob, DS for their support of the last few streams. Hunter as well. Your guys' financial support during this kind of like Supreme Court arc, where we're covering something that I know isn't drama, it's not debate, it's not guaranteed to get a bunch of viewers, but it's something that I feel like is something good for the community. It's good for you to know what the justices said if you care at all about their decisions and stuff, whether you're an abortion rights activist or a pro-lifer. I think knowing about this stuff will help you in debates. It'll help you formulate your opinions on it. I was forthcoming with Pisco about how over the course of reading these things, my opinions go up and down depending on the opinions that we're reading. So if you're going to a news source, it's only giving you one side of that argument, or you're watching Twitch politics debates where it's unlikely they even read the document, then you're going to have a really skewed opinion of the way that things are working here. And you certainly aren't getting a balanced diet of both sides of this. I can say that both for the pro-lifers and the abortionists, that, they're not giving you like a good whole-throated opinion based on the Supreme Court decision. They're often giving you things that are coming from philosophical grounds about their general beliefs about abortion, as opposed to the actual topic at hand, which is the opinions of the justices and what that means for the future. Yet they will happily comment on what the future of things could be without reading these documents. And to me, that's a little bit frightening. But if you're here, maybe you think the same way and want to, help with this. You did us Walmart shoppers dirty. I mean, I can criticize you guys while still being in the same group. This might be a yikesy parallel to make, but I've been watching Atlanta, which surprisingly in the UK is on Disney Plus's website, so I don't even need a VPN to get access to it. But like in there, I think that you have a similar thing where it's like you can have legitimate criticisms for your community or your people or whatever while still living within it and not liking the place that you have in it. I think there's a lot of commentary in that show about that, especially as you kind of get into the later parts of it, but it's something that kind of flows through the entire thing. I know that Steven has talked about Atlanta before, but if I recall correctly, I think he said that he didn't really watch it. I could highly recommend it. The episodes are only like 20 to 30 minutes long, so they're quick, they're easy to consume, and I've really been enjoying it. So it's a really cool one. Atlanta is really good, yeah, but have yet to start the last season. Well, I mean, I'm on season 1 still, so I'm enjoying it at that pace, leisurely, getting through a few episodes every day or every night, really. So that's been cool. But yeah, that's most of what's been going on in my life. I'm probably going to start re-listening or rereading Black Box Thinking, which of course we talked about in one of the last streams. It's about comparing the airline industry and the way that they handle mistakes and regulation, and comparing that to things like the healthcare industry or the criminal justice industry or big tech or banking or finance or other places like that, and seeing what is a just culture? How do you iterate on design and systems to better improve outcomes that you have? How do you view mistakes? How do you view problems? How do you punish people? How do you create a culture that's okay with reporting mistakes so that you can fix them, right? It covers a lot of that stuff, and it's been helpful. It's made me rethink the way I've been running BIA, or even the way that I ran, whatchamacallit? The way that I did essay writing and editing back when I did that. Was I creating a just culture where people would be willing to ask questions and talk about mistakes they were making or possible mistakes they were making? Probably not. And looking at things as system problems and not people problems is another one. It's not very often that somebody is maliciously trying to like destroy a system or ruin a company or something like that. And if you even let that possibility enter your mind for a moment, it can really cloud your decision-making capabilities as a leader. And so you have to be thinking about that. You have to be thinking about, how do I improve the system so that the people in that system don't make the same mistakes over and over? And how do I look at it from a third-person perspective, and this is what I have a really hard time with, and see how the systems could improve me as a person and improve my contributions to the organization. Like, one recent example that I came across when I was meditating on it, which I would highly recommend in case you don't meditate, is I think that I think instructions are so clear and so concrete, and by giving an example, I'm giving people all the tools that they need to replicate what I'm asking them to do, and then I will dump upon them multiple instances of that task. And I think what I need to start doing is not investing the time in creating an example, but actually working with somebody through 1 or 2 or 3 iterations of a task in developing in them this kind of desire to take the wheel from me and continue to do it, which is something that I used to do when I did tutoring, but something I certainly don't do when I was doing essay writing, or now when I'm working with the BIA or with the volunteering project that I'm doing. Like when I'm tutoring kids in math, I'll often keep doing the math equation over and over and over again until that student feels confident enough not only to do it themselves, but they want me to stop because they're getting sick of seeing me do the same thing over and over again. They want it to end. And I think that's the point that I need to bring people to with BIA contributions or contributions to the volunteering project, or really any other kind of work that I give people. I need to work with them through examples in real time so that they can see how it's done, they can ask questions about it, and they build up a confidence through doing it with me to the point where they want to start doing it themselves, and then carefully guiding their hand on the tasks that they do afterwards, and really babysitting that person for a bit until they're producing results that are in line with what I'm asking for, rather than dumping onto them an example and explanation and then crossing my fingers and hoping that they produce the right results. So there's been things like that that have been useful insights I've gotten from that book. And whether, you know, you work on your own or you work for a company or anything else, it might be helpful for you to look at that book and give it a listen and glean some insights from it that you might not have had otherwise, of which I've had a lot, enough to justify going through the book again, taking some notes, and then meditating on those principles and seeing where they could fit into my businesses and my, you know, volunteer endeavors right now. So that's what I'll be working on personally, and maybe give you some insight into my life and whatever. Why meditate when I could be overwhelmed by anxiety? Yeah, I know it's a joke, but like yesterday, or no, 2 nights ago, I think it was, I meditated until the point where, so meditation is this weird thing where like the states of mind that I reach are heavily influenced by like influences in my life. So I think to a quote from the Polish writer who did the Witcher series, I think he was Polish, where he talks about you mistake the stars reflected in a pond at night for the sky above, or something like that, where you're mistaking the reflection of things that exist for being the real thing. It's kind of like in a sort of like an allusion to like Plato's cave or whatever, where you're seeing shadows on the wall and you're taking those shadows to be the base reality, when base reality goes further and further down and you never quite get there. And when I finally hit clarity, which it's been a while since I've hit that point with meditation, to the point where like I deceive myself into thinking that I've hit it recently when I haven't, that moment where like, so when you're meditating, at least for me, you're using a kind of mantra or something to constantly bring your attention back to a really simple task. So like when you're doing a really basic Zen meditation, you're counting your breaths up to 10 and then you restart. So you go in, 1, out, 2, in, 1, out, 2, in whatever, 2, 3, 4, 5, 6. And then when you hit 10, you're meant to restart. And you know that you were losing track on the task if you find that you've counted up to like 14, 15. And then you compose yourself, you return to 1 with the next breath, and you continue until you're consistently hitting 10 every time. And I pushed it even further this time. And what I do is I make that task that my brain is focused on simpler and simpler. So instead of 1, 2, 3, 4, whatever until 10, once I'm hitting 10 consistently, then I go into in and out. And I really focus on what it feels like to breathe. And I let all the sensory information kind of waft over me. And then you hit this point where everything seems to, like, where your personhood disappears and you let go of the reins and you let go of the mantras and you let go of the practice that you're focusing on, and nothing pops up. There are no thoughts. There are no images. It's just stillness. And the one thing that broke me out of the stillness was that line from that book about the stars reflected in the pond at night. And it was just like, oh, wow. I haven't hit that point where there are no thoughts in a really long time. And hitting that point reminded me of why meditation is so wonderful, because it's a practice. As you get better and better at it, you can hit that point more and more. And you don't need to be in a still environment to do it. You don't need to be counting your breaths for like 30 minutes or whatever to do it. You're able to do it on the train and on the bus and on your lunch break or wherever else, even in busy environments, and you're able to get there. And I was reminded at how helpful it is, because when I used to be living in the van and stuff, I could do that all the time, of like hitting that moment of there's nothing, there's no input coming in. And if there is, it's not really sticking with me. It's kind of like bouncing off of me, like something bouncing off of like still water, and how quickly the water returns to being still is the measure of like how well I've achieved that state or whatever. And it felt really good and reminded me of why I used to meditate a lot more than I do now. And when you hit that point, then you can start to focus on individual tasks, and you're in like a super state where like you can focus on a task and really keep on it. And that is part of the benefit of meditation, is like it's flexing the muscle of control and attention. And you can use that flexing just the same way that you would use lifting weights to do practical things with it. So instead of focusing on my breaths and really focusing myself into that task, I can focus into evaluating what's going wrong with working, or a really weird position for me to be in. Look from the outside, pretend you're an outside person, and what would be the criticisms of your performance here? What are the things that you could do to improve this? And that's where I got that insight about like, I'm dumping tasks on people and I'm not building them up to the point where they want to take the wheel of the car away from me. Instead, I'm like explaining to them where all the pedals are and stuff. And I labeled all the pedals and all the gears and the steering wheel and gave them instructions, and then expect them to be able to drive the car. And that's not really how that works. And I know that's not how it works. And I remembered back to tutoring, and I don't think that insight would have come to me if it weren't for meditation. And so that, like, if you're ever wondering why practically, not the woo-woo people, but why practical people are interested in meditation, that's going to be part of the reason. There's anxiety control and other reasons that it might be helpful to you as an individual, but like, that's a lot of the benefit for me, is because if you can flex that muscle, then it's ready in situations where you need it, like focusing on those problems and coming up with insightful answers to the questions that you're posing to yourself. So, you know, that's what I think. Meditation is like exercise. Even if you're not doing it perfectly, it's better than not doing it at all. True. And I've been meditating a lot more living in this house in the UK than I did before. And it was through the daily, multiple times a day meditating that I eventually hit that point where everything was still and I was reminded of why I do this. And so, yeah, it's definitely a practice, and you have to get better and better at it. And I know from experience that there are places you could put yourself outside of that experience that is above it, like remembering memories that you thought you had like forgotten a long time ago. Or putting yourself into like emotional positions that on a whim whenever you want. And those are kind of the higher level things that you kind of build up to. And I was able to see that whole road clearly by practicing a few times every day, never getting to the point that I used to be at, but getting better and better at it. So yeah, it feels like reverse ADHD, kind of, yeah. Yeah, a little bit. It's just a return of control and like power in your life. Like having power over that muscle, that organ that is your brain, is like super nice to have. And I don't think many people have it just off the bat by doing stuff in their daily life. I think it's something you have to practice. Similarly, I don't think you could be expected to like pick up a couch or a fridge on your own if you don't train your muscles to be better at accomplishing those tasks. Some people may be weirdly strong and able to do it, but most people aren't. So you're going to have to like work up to those things. And that's part of the benefit of it for me, at least. I need to try meditating, but my ADHD is so crazy. I never get my brain to be quiet. Well, remember, it's a practice. Like, coming from somebody who used to do it a lot, like, I'm not as good as I used to be. And I see how doing streaming, doing internet stuff, watching YouTube videos, all this stuff takes away from my ability to do that, in the same way that eating junk food and stuff all the time makes you lethargic, makes you feel bloated, and makes you unable to do the physical things that you would otherwise be able to do, right? So, you know, just you're not going to get there immediately. That's been your experience. You don't need me to tell you that. But like, once you get there, it's a really good feeling. And then you just keep up with the practice of it, right? So that's what I would say. Don't expect that you'll get there from the get-go. It might take weeks. It might take days. It might take months. So just to bear that in mind. Yeah, that's a bit of word to the wise, in case you had been thinking about it but never followed through with it for a variety of reasons, like you never get your brain to be quiet. Also, and this should be noted, there are different purposes to meditation, and the purpose is not always to make your brain quiet. That could be your personal goal, but it's not always the point of like a meditative session. Like, I use it all the time to think about problems from perspectives that I wouldn't have if I was in my everyday mind going 100 miles an hour mode, right? So, you know, just bear that in mind too. The point isn't always that the thoughts don't come. Part of the point initially is that you don't get worked up in those thoughts. So like, thoughts can come, but the first step is like being able to put yourself outside of the thoughts. So you might not have that clear lake at night where nothing is beating on the water and it's perfect, like it's a crystal mirror. But if you're able to remember that you are that water that is being displaced by the ideas and the thoughts that pop in your head, and that the ideas and thoughts will come and go, and some days may be worse than others, that separation between the thoughts and ideas and who you are as a person is an important step in the process there. So realizing that all these ideas and thoughts come from a place inside of you, and that can calm or agitate depending on what's going on with your circumstances, and more importantly, the things that you're exerting control over, whether it's environmentally, like being in a simple space that is relaxing to you, or you're putting headphones on to block out like external auditory distractions or things like that, right? You start to learn that those things influence it, in the same way that maybe you don't realize how unhealthy you are until you go for like a really long walk, or you don't realize how much like drinking a bunch of soda all the time will impact your health until you are doing these exercises and doing that, right? Because then you're testing yourself and you're seeing the difference, right? So that can be part of the initial benefit of meditating if you have something like ADHD. So that's what I would say there. Do you feel like you have an easy time being intimate with people through conversation? It depends on the person. In general, yes, but I've learned that particular kinds of people I struggle with for different reasons, so it just kind of depends on the person. But in general, yeah, and you get better and better as you learn about more people and what makes them tick and stuff. So that's what I would say in regards to that. But yeah, so there's my brief plug about, meditation to close up the stream for today. I hope you guys enjoyed. Once we're done with this arc, I'll try to do a general just chatting stream, maybe a Discord Q&A where I have people on and talk with them like we've done a couple of times now. And then we'll be done with this arc. I look forward to it. As much as I enjoy Pisco's company and covering this, I look forward to a day when I know that streaming is not reading Supreme Court documents for hours on end. I'm not going to lie. So anywho, if you're excited about that, just know I'm equally excited to get back on that train. We could talk about cats and how you're definitely going to get a cat. We could talk about that once I return. So at the end of July or the beginning of August, I will hopefully be moving, hopefully to North Carolina. I say hopefully because there's a lot of doubt in my brain about how well that'll work out, but I guess that's yet to be seen. I need to not defeat the idea before I figure out what the outcome is. Otherwise, I'm more or less guaranteeing the outcome. So hopefully I'm able to do it. But if I am, then I'll be in a stable place for 6 months to a year, probably a year, and I'll be able to do more streams with you guys and plan out my life a little bit better and not be stressed about travel or my differing circumstances of housing and such. And I'll be in a better place to do this. So that all being said, it's been great doing this. Big thanks to Pisco for coming on and spending hours and hours with us. It's very cool of him. And I will talk to you guys later. Have a good rest of your night. Hope you enjoyed the stream. If you're a VOD person, comment down below. Let me know what your thoughts were on today's stream. And I will talk to you all later. Have a good rest of your day, your night, your morning, wherever I've managed to catch you. And whenever I've managed to catch you, I will talk to you guys later. Have a good rest of your night. Or at least it's nighttime for me. Goodbye.